to do the court cry.
We are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome everyone to the Massachusetts Appeals Court. This is a special Zoom hearing of 7 cases this morning. I'm Judge Milkey. With me are my colleagues, Judge Massing and Judge Hershfang, and we are the panel on all 7 cases. Our first case is 2021 P436, Lay versus the City of Lowell. I want to remind the parties that we have read the briefs and we're familiar with the facts. So we urge you to cut to the chase to the extent possible. If, however, you felt you have said everything you have to say, there's no shame in sitting down. As one of my former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will turn the floor over to Attorney O'Connor. I would ask you, though, however, we understand that Mr. Lay has been reelected, so we are interested in hearing from the city why this appeal is not moot.
Certainly. Good morning, Your Honors, and may it please the court, Christina O'Connor. I am representing the City of Lowell in this matter, and with me this morning, although not on camera, is Attorney Nicholas Anastasius. To start by answering the question that the court had raised as to why this isn't moot, this is a matter that arises in equity, that really touches upon all of the principles of equity to do justice, to avoid unclean hands, to promote the public interest. And this is also in furtherance of the whole line of cases under Crink and its progeny that where there is the public interest at stake. In this case, Mr. Lay was under a brand new system introduced to city elections, district representation, was reelected to district representation for the school department. However, the issue remains before the city, and I would submit it remains before this court to be decided fairly and firmly as to whether the evidence that has been presented thus far by the city, at a minimum, calls into serious question the residence of Mr. Lay, or whether it is sufficient in and of itself to date to conclude that Mr. Lay is in fact not a resident of the City of Lowell.
But Attorney O'Connor, I apologize for interrupting, and please tell me if there was any trouble with my audio, since that is historically sometimes an issue.
Working fine.
My understanding from the party's briefing is that in order to be considered as a candidate for the school committee in Lowell, someone who wishes to run needs to file certain paperwork that includes an affidavit or some other similarly legally binding declaration of his or her residency. Am I right about that?
Yes, Your Honor.
And so may I presume that Mr. Lay did whatever necessary paperwork he needed to do in order to be reelected this most recent time?
He did. However, I don't know if you were about to say
well,
something.
I think you probably anticipated my question, which is why is that not adequate and why does that not make this moot?
Sure. So normally it is adequate. But however, in this case, and really in the whole line of these types of cases, what changes is once a question is raised. And in this case, once that happened, and once the residency issue was explored, and I would submit once the evidence that is detailed in our brief was laid out before the Election Commission, as well as the Superior Court, then you have a change of circumstances. And those circumstances are what you see in really all of these cases that go before boards of registrars when these issues are raised. In terms of
I'm going to, Attorney O'Connor, so assuming that it's still, still ripe for review, what is the date that we're supposed to be looking at for Mr. Lay's residency? Is it November 2019 when he was stood for election, or is it February whenever it was when the Mr. Hoey resigned?
I would submit that it's we can look at both of those dates because he fails to meet the standards for either of those dates. But the critical date was when the date that he ran. But he was not eligible in 2019 based on the evidence that we submitted, nor was he eligible to sit when the vacancy occurred. And under
I'm sorry, so back to the mootness. So the issue of what his residency in November 2021 is what would matter for now. I mean, so what if we ruled in your favor here? It doesn't affect his current seat, does it?
The facts as we know them haven't changed. And if he was in fact ineligible to run in 2019 because of falsified information before the local election commission, then that would and should render him ineligible for further service.
What's the falsified information? I mean, I'm familiar with all of the information that I think was placed. Actually, let me ask you about that.
Sure.
The volume 2 of the appendix, it seems to me it has all the complete submissions of the city of Lowell and Mr. Lay before the election commission. Is that the entire record? Was that entire record also placed before the Superior Court?
Yes, everything that is before the appeals court is what was proffered before the Superior Court, with the exception of the there's also
the Rule 60 motion.
Yeah.
The Rule 60 motion. But okay, so aside from the Rule 60 motion, you said he falsified information. What of that record is falsified?
It goes to the heart of the representation that was made that he is in fact a resident of the city, and that when you review the records that the city has produced.
So you're not saying there's anything that he signed under penalty of perjury that's false. You're just saying the totality of the record brings into question the veracity of him being a resident.
Well, actually, Your Honor, there were records that were submitted both to the city as well as to the city of Brighton that are records that are submitted under oath. There was also his testimony, I would note, that was before the election commission, and the documents that he filed to the election commission, and you cannot reconcile those documents.
Do we have his testimony? Do we have his testimony in the record, or is it just what you wrote in your brief, your version of his testimony?
It's just what was in the brief. He actually refused to testify. However,
but we don't have any record of him refusing to testify. It's the representation on page 31 of your brief is the only evidence of that.
Yes.
Okay.
And so just to clarify, if I could, on his testimony, Mr. Lay, when given the opportunity before the local election commission to answer to what ostensibly are very serious allegations, he refused to testify. One of the election commissioners then at least asked for a copy of his registration. He left the room, came back with a sack full of documents, and then represented to the election commission that he no longer had the automobile, that he sold it. He was then asked for the bill of sales. He then stated, well, actually, I gave the car away.
All of this, I'm sorry, all of this that you're saying right now is based on your recollection of what you personally witnessed, right? It's not in the record.
Right. It's what we have argued before the Superior Court.
Yeah, but on a related point, to what extent, from your perspective, is there an agreement between the parties as to what the administrative record before the Elections Commission was?
Well, I think, Your Honor, that goes, I can answer that, but it also goes to the heart of looking at this from the standard of a request for injunctive relief. So what was before, we had a short period of time. The city did attempt to put together a transcript and had a transcript, but in the 2 days that we had between the initial hearing, it wasn't produced to the Superior Court.
No, but wasn't that your burden? I mean, and typically, at least under 30A practice, the agency puts together the record that then gets reviewed by the court.
That's correct, Your Honor. However, again, as I had said, this goes to the heart, if you will, regarding the argument relating to converting a preliminary injunction motion, which twice for both hearings, this was the notice to the city was for a preliminary injunction hearing. And yes, even though this isn't under 30A, because it's not an agency that's recognized under 30A, I would submit to the court that that this would, as suggested, follow under that same process, and it would be the burden of the city to produce a record. However, for injunctive purposes,
counsel, if there is in fact doubt about what the administrative record was before the commission, then arguably the proper remedy, were this appeal properly before us, would be to send it back. Where there's been a subsequent or intervening election, why should we even hear this appeal as opposed to having the parties start over and develop a better record and perhaps more than have one person on the commission vote?
Thank you for that question. The election commission, to be clear, could at any time bring an individual back where there is an issue raised, as in this case, and further examine the voter as they satisfy the voter registration. In this particular case, given the pendency of these proceedings, everything took a pause, and we did not do that for fear of further confusing the issue while it is pending, or taking any action on this matter while it was pending. But what I would submit to the court, if I may, if we do look at what was submitted by the city, the evidence is very compelling, and you cannot reconcile it. And it does absolutely raise the issue of unclean hands, which runs completely contrary to matters of equity and matters of public interest. In this particular case, what I'm referring to is there were affidavits signed to the City of Lowell Assessor's Office, which are referenced in our brief, that indicated that after purchasing the property in Lowell, the residents would remain in Brighton. There was never a change to any of those forms. Similarly, since 2015, as indicated in our brief, Mr. Lay has been the recipient of a residential tax exemption from the city of Boston. The reason that is so significant is under Chapter 90, a fairly recent change to the law took place. And if you satisfied any one of a host of criteria, and included in that is a residential tax exemption, that is prima facie evidence of where your actual residence is. In this case, it indicated that it is in Boston and Brighton. And that would require a shift of burdens, which never took place. That evidence was never rebutted. What has been offered
Counsel, I think we understand that argument. Let me ask a specific question. Sure. The judge specifically ruled that the city bore the burden of proof in the proceedings before the election commission. Do you agree with that?
Yes.
And let me ask, typically when you have if you will, and I use this term loosely, adjudicative body, you have a separation where you have, if you will, a prosecutor who is making arguments to the adjudicative body. How are we supposed to think about this particular situation? Who was, if anyone, was the prosecuting entity to the extent that the Elections Commission was a neutral arbiter.
Well, Your Honor, I would submit that the proceedings before the Election Commission had all the necessary indicia of a hearing. There was ample notice to Mr. Lay. In fact, much more notice to Mr.
Okay,
Lay.
but who was prosecuting the case that he was not a resident?
The case was presented by the City of Lowell Law Department. However, he was also represented by his counsel. The Election Commission was free to, they didn't have any sort of independent counsel, if that's the question. However, the board didn't request any, and the board did ask questions of Mr. Lay, but as I indicated, he refused to testify and/or cooperate before this hearing, nor did he, I would submit to the court, proffer evidence that could, in any sense of fairness, be considered credible.
Well, we
I-
do.
I-
Oh, sorry.
I'm sorry, go ahead, Justice Hershfang.
I just wanted to follow up just for a moment on that, Attorney O'Connor. My memory is that there is an affidavit from Mr. Lay attaching a series of documents in support of his contention that he was actually a resident of Lowell. That is part of the administrative record, right?
It is, and I can see that my time is getting down to
You are
the
free
seconds.
to answer questions.
Okay, thank you, Your Honors.
I've got some more questions for you. I'm sorry. You said that there's not a 30A review because it's not a proper, not correct agency for that. Would you agree that the action is under Chapter 56, Section 59?
Technically, this is a matter that arose under a special act of the city that's unique to the City of Lowell, Chapter 230 of the Acts of 1954. Because there was the opening, this was not a typical type of appeal under or proceeding under 50 to 56. However, similar to my statements with respect to Chapter 30A, the city would agree that that those are the guidelines, I think, as to what, in fairness, any kind of a hearing or any kind of proceeding in consideration of these questions should follow.
Okay, so I mean, because Chapter 56, Section 59 gives the Superior Court sort of a general equity power to review the election matters. So you'd say that was an appropriate use of the Superior Court's power.
I would agree that yes, the Superior
okay.
Court has the equitable review, but if I could, Your Honor, if I could just add in that the equity in this case would, and in these types of cases under 50 to 56, wouldn't actually even limit a court to traditional rules under civil procedure. That equity would require, and does require in these cases, a court, when necessary, to go beyond that, and that perhaps would touch upon the other evidence that we wish to submit.
Okay. Gotcha.
There are other people.
So that leads to my next question. And then, are we really? What are we reviewing? Are we reviewing the Superior Court, or are we reviewing the agency?
I would submit that we are reviewing the action of the Superior Court. It's the action that the Superior Court took that that obviously is addressed in our brief, but that is the action at hand. And if I could answer the prior question of Judge Hershfang, did I pronounce it correctly?
Close enough.
Sorry, I apologize.
All right. The mouthful.
It went to the I believe your question had related to the residential tax exemption and the standard.
No, I was actually just asking in general. I mean, my memory of Mr. Lay's affidavit and the attachments is that it addressed a number of sort of vectors of contention of domicile. So I was just checking on the record on that. While I have you though, Attorney O'Connor, may I overly extend our time just to ask one more, perhaps overly pedestrian question, but assuming for the moment that we don't think that this appeal has been rendered moot by Mr. Lay's subsequent reelection. What is the city asking for here? What is the redress if you win?
Well, again, based on the evidence that the city has submitted, we feel that there is substantial evidence and that the initial decision of the Election Commission should have been sustained by the Superior Court. And that if that happened, then Mr. Lay wasn't qualified to take that seat. He's also, I should note to the court, he was listed in this current election as, running as a re-incumbent. This decision also affects that as well. He wouldn't have been a re-incumbent. He wouldn't have had the advantage, whatever advantage comes with that. But I would,
and what flows from that? We're supposed to make a determination that, his chances were enhanced by something that was unjustified. Therefore, what?
So if if the decision were from the Election Commission had been sustained and the Superior Court decision was reversed, obviously it could be referred back to the Superior Court, but I would submit that if the Superior Court decision were reversed and the Election Commission decision was sustained, not disturbed, that at this point, it should be then, the entire matter should be referred back to the Election Commission for further proceedings consistent with the order of the appeals court, this court, as it relates to this current election. And they would then take action.
Okay,
if he was deemed not a resident for the city in 2019, that still carries.
Council, I'm going to try to wrap this up. Judge Massing, do you have any further questions?
Just two quickies. How many election commissioners are there? Is it three?
There are now 4. There were 3 at the time.
There were 3. I mean, how many are provided for in the charter or wherever?
It's now a full complement 4.
Didn't anyone ever say you're not supposed to have an even number on a board?
and is there like in the charter, the bylaws or anything, are there rules about, the composition and voting and stuff like that of the commission? We don't have that before us, but is there?
There are, Your Honor, and it's intended to have a balanced board, which I think goes to Judge Milkey's apt point about not having an even number, but it's designed to have the 2 parties evenly represented. So it comes at a price.
Okay, that's all. That's enough for me. Thanks.
Judge Hershfang?
I'm all done. Thank you.
Thank you very much. We'll hear from Mr. Lay, or at least his
Thank you, Your Honors. Good morning. May it please the court, Attorney Roland Millard for Mr. Lay. Judge, the City of Lowell's case is an argument in search of a sympathetic ear, and so far it has fallen on deaf ears 3 times at the Superior Court and once in front of one of your colleagues sitting as a single justice at the Court of Appeal. The city's argument is unavailing each time. Each time they go up for next layer, they include all the papers that were unavailing the first time. So a case that started out with maybe 1/4 of an inch of paperwork is now roughly 3 or 4 inches, and it is simply the same paperwork being churned to sustain the same unavailing argument. There are a number of aspects of this case that have been repeatedly put in front of the city that the city has failed to address adequately. 1, on all of their claims with the tax issues, on every single article, whether it be realty or personalty, Mr. Lay's sister is a co-owner of the property, and the city has failed to address how the sister's co-ownership affects the argument they make with respect to an abatement from the city of Boston, or whether the excise tax bill was paid to the city of Boston. Mr. Lay's sister co-owns all of that property, and it is
so Mr. Millard, her name then would be in the record. What is her name?
Her name escapes me at the moment, Judge, but she lives at the property in Boston with her daughter. It's a duplex.
She would be the other person listed if I look at it.
And in all the record, Judge, there's a copy of the deed and all the other papers. Her name is in the record.
Is she on the Lowell property too?
Yes, Judge. which, as a matter of fact, the relationship Mr. Lay has with her, which has been submitted in other papers to other courts, she's the one who actually stays on top and is actually like the manager of the property, which is why the real estate tax bill and the water bill for the property in Lowell gets sent to Brighton, because the sister's the one who writes the checks to pay those bills.
Attorney Millard, if I may, it looks like from the quitclaim deed that I see in volume 2 of the record appendix, page 9, her name is Lynn Lay.
That's correct, Judge. That's correct.
But so this, I mean, is the information you're telling us now, I gave Attorney O'Connor a hard time about her representation of what was occurred at the hearing. Is the stuff you're telling me now also stuff that is not in the record before us?
No,
Except
Judge,
for,
it's in the record, and those representations were made in front of Judge White. They were made before the Election Commission. They were made in front of Judge White again. They were made in front of Judge Saroof.
no, but like, for example, the fact that the tax bills are sent to the sister in Brighton, is that in the record before us?
Yes, Judge.
Where?
I believe it's in Mr. Lay's affidavit, I believe.
Okay.
But is it in the record before the agency?
I believe I told them that, and in one of the parts of the appendix, I submit all the documents that were submitted to the Election Commission, both by the city and by Mr. Lay. This volume right here, this was attached to the papers, and they were submitted to Judge White in the first
Okay,
hearing.
well, I want to be precise about this. Same question I asked your sister. Is there agreement, from your perspective, is there agreement between the parties as to what the administrative record before the Elections Commission was?
I would say it was that volume right there, and they didn't object. So I would say my answer would be yes, and that binder right there was the administrative record. However, there is no transcript of that proceeding, but the papers that were there for everybody to review are in that right there, and I believe a copy has been sent to you as part of your records.
Okay, one of the interesting debates between the parties is whether or not the unanimous vote of one on the merits constitutes a valid vote of a necessary quorum, or however you want to phrase the issue.
Clark v. Merrill, Judge. I've cited it in my brief. Clark v.
No,
Merrill.
I understand the nature of the debate, but that's a question of law, and just assume for the sake of argument that the city has the better argument on that, so that it was a valid vote at least. In that case, isn't what was before the judge properly seen as a review of what the Election Commission did, and as such should be confined to the administrative record before that agency?
I would say, Judge, that the complaint I filed controls that. And I filed a complaint for injunctive and declaratory relief, not for a review of the administrative agency's decision. And I would argue,
how do you get to do that if this is really a question of administrative law, whether or not a vote of the Elections Commission was just justified on the record before it?
I would submit to the court that that burden and that argument should have been made by the city in their answer. The city should have answered that the complaint was improper on its face. The proper complaint should have been a complaint for judicial review of an administrative agency's decision. And
But the judge's ruling is a little split in the following sense. There are, I believe, statements in there where the judge saw this as an administrative law case on the record. At the same time, the judge appears to have made specific findings as to what was before, and then kind of mixes the issues together about substantial evidence and such. Do you have any comments on that?
If I may just add to that, Justice Milkey, which is sort of I'm furthering Justice Milkey's question. This is not a new question, but as he was speaking, I was looking at the decision from the Superior Court, and add to what Justice Milkey said, Attorney Millard, the very first line of that Superior Court decision is Plaintiff Dominic Lay filed this one-count complaint seeking review of a decision of the election commissioners of the city of Lowell. So add that to the mix.
I would say, Judge, that the use of review in that particular sense, the interpretation would be more the common interpretation rather than the legal interpretation under Chapter 30A. We asked him to look at what the city had done. We wanted injunctive relief that he could take his seat immediately, and pending the furtherance of the case, where ultimately we would get declaratory judgment that he is entitled to have the seat. And so the city, and when Judge White had a hearing and asked us, and the transcript to that hearing is reproduced in the brief, and it's also included in the record appendix, he made it perfectly clear what he was doing. And if there was a problem with what he was doing from the city's perspective, then I would submit to your honors that was the burden of the city solicitor to say, no, Judge, that's not correct. I was perfectly content with what the judge was doing and where he was going and what his grasp of the case was. The city solicitor said she was also content. At the second hearing, where he said, no, I'm going to have a Rule 65 hearing, I'll give you an opportunity here. Prior to each of us making an argument, he said, you've each had an opportunity to submit memorandum. You've each had an opportunity to submit proposed rulings of law, findings of fact. Is there anything else I need? And the city said that they were content to rest on the papers. He then said, would you like argument? Attorney O'Connor said, yes, that would be fine. And then he entertained our arguments. So at no point in time did the city raise an issue at all with what the judge was doing, with what the grasp of the case was, and with what his intention was to resolve that case.
Can I stop you? I hear where you're coming from, but it doesn't address the specific issue that I and Judge Hershfang were raising with respect to the judge said he was doing one thing and then appeared to have done another. And that's a potential problem in any event.
I would think, I would just maintain that the judge was absolutely correct. And a vote of one finding that Mr. Lay is not a citizen of the city, one abstaining, and one deliberately not voting, there's nothing administratively for the judge to review. The quorum on a 3-person board, the quorum is there because they should have 4. One had resigned, so there was a vacancy. So they had a quorum. There were 3 of them. A majority of the quorum can act. That means they need 2 votes. They got 1 to 1 to 1. The director of elections, who was an assistant city solicitor who was advising the election commission, then announced, okay, 1-1-1, you've lost, Mr. Lay. You are not a citizen of the city. There it goes. The very next day, I filed the complaint in the city of Lowell.
Are you the issue, the 1-1-1 issue? Are you raising that for the first time on appeal?
I brought it up in the Superior Court. I also brought.
I mean,
up,
are you saying the fact that it's an invalid vote that you're arguing now? Did you argue in the Superior Court that this is an invalid vote? We shouldn't even be reviewing this.
Your Honor, my argument on that was more along the lines of there was no need for a 30A review because there was no decision, because the vote was 1 to 1 to 1. And that's why I cast this as a complaint for declaratory judgment and injunctive relief, because at the time I crafted that complaint, in my mind, a vote of 1 to 1 to 1 was not a majority vote, and therefore there was, and I addressed that very briefly in my brief to the court, there is no decision here because a 1 to 1 to 1 vote is not a decision.
I know you're arguing that, and I know we can affirm on any grounds, but the judge did not reach that issue. And isn't our consideration of that issue at least somewhat dependent on materials that do not appear to be for us in terms of whatever rules the commission has in terms of its votes and so forth?
I would submit to the court no, because the materials that were in front of the judge made it crystal clear that Mr. Lay is a citizen of the city of Lowell. The city puts words.
Wait, you just changed gears here. The question is the validity of the vote, not substantively, but is it a vote? Is it a valid vote?
I would argue that yes, they were there, they voted, but the vote is 1 to 1 to 1. And the motion that was voted on was that Dominic Lay is not a citizen of Lowell. The person who made that motion is the one who voted in favor of it. Another commissioner abstained, and the third one didn't vote.
How is that different, abstaining and not voting?
I would say that abstaining, there are a number of reasons why, and you're putting on the record that you're abstaining. One of them, you could have a conflict of interest, or there are a number of reasons where it's not voting, you're simply not going to go forward. But I would argue that it is a fine distinction, but I would argue that abstaining is different than not voting.
There's a footnote in Attorney O'Connor's reply brief that says it's the custom or rule or whatever of the commission that the chair only votes in the situation of a tie. Do you agree that's what the rule was?
News to me. I know about it from reading her brief, but every deliberative body I've been in front of, the chair has always voted. I'm also co-counsel of the Drinking Water Supply District, and our chair votes. So I don't. That was news to me that a person who's chair of a committee would not vote. I could understand why, because they have an even number, so I could understand why. But even so, if the chair now has an odd number of people there, I would suggest to the court, wouldn't that be the opportunity to abandon that position? Because now you've got an odd number.
Jim, let me ask you another record question. We don't have the transcript of whatever happened before the commission. Attorney O'Connor said they were trying to prepare and they didn't have time. She says in her brief that your client chose not to testify. Is that true?
When I was there and I was hearing the questions, and the fact that the city solicitor's deputy assistant, one of her assistants, is the director of elections and is advising them, I knew which way this wind was blowing, and that's why the very next morning the complaint was filed in Superior Court. I advised.
So is that a yes? He did not test. Is that yes? He did not.
I advised him not to testify.
Okay. And how about this thing about unable to present the car registration? He claimed it was a gift. He no longer has vehicles. What about that?
The registration, he had gifted the car to someone, and contrary to what the city put in his brief that he wanted the address redacted, he wanted the address of the person who got the car redacted for her privacy purposes. He didn't want his address redacted. He wanted her address redacted.
Okay. So something like that happened, but we don't have a transcript of it.
May I address the question of mootness?
Please.
Please.
I would argue that the fact that Mr. Lay was reelected and he was challenged in that election puts that to rest. He has obviously been living there. He filed this complaint. He's gone through a number of hearings, both in the Superior Court and one prior hearing in the Court of Appeals, although that was, I believe, an administrative one on paper. So he lives there. He's been reelected. But the reason I feel that the court should rule on this is where Mr. Lay has asked for his attorney's fees and costs. The city does this because it can. And I would submit to your honors, all of whom practiced law before your honors became judges, what client, after losing 3 times in Superior Court and once before a single justice of the Court of Appeal, would then fund an appeal to a 3-judge panel of the Court of Appeals? Mr. Lay has been forced to pay out of pocket and go on and on and on, while an institutional litigant with vast resources simply drags him through the legal system.
So you're saying it's not. Yeah, so you're saying it's not. It is moot, but we should address it anyway. So your client can get fees.
I think that the issue of attorney's fees and costs for a private litigant who has to go forum to forum to forum against an institutional litigant, because the institutional litigant has a legal staff that's being paid out of the public purse, whether they're writing another brief, sitting in a school committee meeting, advising a school committee, they're being paid no matter what. And the private person has to go and go and go. And the private person continues to win at every level he goes to and has nothing to show for it. but the win, and then a subsequent notice that we're not satisfied, we're going forward. Every single judge that has examined this case has found Mr. Lay is a citizen. The only person in this entire scenario who is unhappy with these results are the city. And the city is the one who doesn't see what is right in front of them. In their brief, they put in his residential address for a statute about mailing an excise tax bill. The statute does not say residential address. The statute says address, and the statute makes clear in the next paragraph why it can't be a post office box. It says that is so that in case you have to institute litigation, there's a place to serve the papers. It doesn't say residential address. If you own a car wash and put down you want the papers sent to the car wash, that doesn't mean you live at the car wash. Where they're arguing on chapter 90, section 3A.
Okay, counsel, we understand your substantive arguments. So unless either of my colleagues has any follow-up questions, I think we're going to have to bring this to a close.
Thank you, Judge.
Thank you both very much. Interesting matter.
We are live and on the record.
Thank you very much. We are back for our second case of the day, 2020 P 1165 Weeks versus State of Patricia Powers. I want to note for anyone watching that we were unable to get Attorney Earhart's video to work, but he is present and will do the argument. Just a couple of things. We're assuming the attorneys are familiar with this. 15 minutes per side, no opportunity for rebuttal. We have read the briefs. We're familiar with the record such as it is and the arguments. So we would urge counsel to cut to the chase. In one preliminary before we start the clock, the panel did receive yesterday a letter from the present owner of one of the properties in question. We have it. Not sure exactly what to do with it, given that the writer of the letter is not a party to this case, and more fundamentally, we are an appellate court that does not ourselves find facts, especially those submitted in this form. That said, the briefs themselves reveal that the property has been sold, and I know at least some of the panelists have questions about the ramifications for that with regard to, for example, any relief that we were to provide in the pending appeal. With that, I will turn the floor over to Mr. Earhart. My understanding is that he can see all of us, and that will include, once we start the clock itself. So, Attorney Earhart, the floor is yours.
Yes, this Miss Caitlin Millett is the current owner. Her actual complaint has nothing to do with all what's going on. Mrs. Weeks has a rooming house there. She rents to people. When they moved in, they found this out and got upset, and they put it on. They got some people together and put it on the. That's according to decades old bylaw in Longmeadow, which a lot of elderly rent their homes. It gives them extra income, it gives them protection, and it gives them companionship.
Okay, counsel, I have no.
That's right. That's what goes on. So, bottom line is, they tried to get that bylaw moved. It was overwhelmingly approved by the town meeting. Her boyfriend started.
Okay, counsel, I really don't want to.
Bottom line is, this has nothing. There is no harassment order. There is no nothing. We got a security camera protecting us from them, and that's it.
Okay, counsel, but let me get to the subject at hand, namely her complaint in the letter is with regard to the filing of an easement on the deed. I went back. This prompted me in part to go back to look at the judgment in question, and I learned that in fact there appeared to be two judgments at least with regard to this case, notwithstanding the rule that a civil case is supposed to have only one judgment. And there is a judgment that I do not believe is included in the record appendix, but is publicly accessible through the court system, that deals with the easement issue. And Ms. Millett avers that this was filed on her deed. Can you tell me, has this also been filed on the Weeks deed?
This was brought by Attorney Parker because he felt that accordingly that if there wasn't a deed, the easement would expire. You need a deed in order to have an easement continue. And he was the one who asked for that, and the court granted it and asked him to draft an easement that would cover our property.
Okay, but was the easement filed on your client's deed?
I do not know. Maybe Mr. Attorney Parker can tell us that.
Okay, we were asking the same question. I do want to just note for the record that given the context of this, the filing of the easement on the Millett deed, to the extent that that has occurred,
it's in her behalf. It's in favor of that property.
I understand that, and we'll hear from Mr. Parker on that. But I think Ms. Millett may not understand the context of that and how it was designed to offer her benefits and not liabilities. But in any event, my role here is not to advise her on that. Can I, just turning to the merits, this is an appellate case.
Yes.
And it's partially a review of what the judge did on the motion for partial summary judgment. Our review of a decision on at least the granting of a motion for summary judgment is de novo, but it's de novo based on the summary judgment record. You have not provided the summary judgment record. How are we supposed to do our job as an appellate court without that? And the same with regard to the trial portions of this case. Our review of a trial record is, generally speaking, limited to evidentiary rulings, jury instructions about the law, and extremely limited view of the facts in the J&OV context.
Your Honor, the reason that there isn't a record in that regard is that the court, in its ruling, specifically ruled on put the evidence in record. This says, this is what I'm ruling on. This is the evidence on which I am basing my decision. And that being the case, that's all that was really, but we agree. We're not arguing with the facts that she found them. We're saying the conclusion she drew from them were incorrect.
Okay, but for example, it's a basic rule of appellate laws, I'm sure you're aware, that we can affirm on any ground. What if the summary judgment record reveals additional facts in which the judge did not specifically rely, and that the judge may have been correct for a different reason?
The fact of this matter is that this is a relatively simple fact situation. There are nothing really outside of what she talked about. The question, for example, of whether there is a prescription easement, the question is, it really comes down to was it open and notorious use of that pipe under her property, under the Weeks property? And if so, the Weeks should have known about it and therefore should have taken some action. The only two facts there are that there was a drain in her when they bought the property on Weeks's driveway, which had water at the bottom, which could easily have come, as she thought, from behind there's a hill behind.
You're talking about catch basin 1.
That's correct.
It turns out that, tell me if there's any debate about this, yeah, that as it turns out, catch basin 1 is on your client's property. Is that accurate?
No, let me put it. I don't know which way. Catch basin 2 is the one that is on Weeks's driveway, Weeks's own driveway, not the Powers driveway. Catch basin 2. When the brook, it's a Meadow Brook goes downhill. It's kind of a V shape. There's an intermittent brook, and when the Weeks property bought it, there's no dispute that there was a pond. The brook ended in a pond in the Weeks backyard, wiping out their backyard. So I'm sorry, the Powers wiping out the Powers backyard. There was only one catch basin that was in the driveway catching water from the Weeks driveway. There was a hill behind them. She thought it obviously was groundwater, which would make sense. Then down the line, the Powers caught onto the brook or came to the property and brought it to the bottom of their driveway, which is a steep driveway.
Wait, but that catch basin is actually on your client's property, correct?
Unknown to us, but it was. But the Powers built it, and in so doing, at some point, it got the water got the water coming down the driveway, and it drained the pipe.
So I just want to stop you. So, aren't your clients charged with the knowledge that this was on their property, even if, as a matter of fact,
that's correct.
They didn't know it?
Right. No, that's correct. We have no doubt that the catch basin being there is something that she has notice of. There's no doubt about that.
Okay, so hear me out. So it's established that your client, more than 20 years before the relevant time period, knew that there was a catch basin installed that they should have known was on their property, that in fact was draining the Powers land.
Right. What they didn't know.
If that is the case, why does it matter that they may not have known the extent of the drainage system on the Weeks property, including the connection with the second catch basin?
Because
especially with regard to a property that appears to be as small as this one.
The fact of the matter is that the catch basin draining on the property merely could have, most likely, and it was considered that it just went down into the groundwater on that property. There was no indication there's a pipe. It happened to be fortuitous that a pipe hooked up right to that area. No one knew about that pipe. There's no reason they should have known about it. Totally, it was not visible anywhere on the property. It was fortuitous that it was there and they hooked onto it. There's no reason why you should assume there's a pipe. We don't have a problem with the drain pipe. It could have gone drained into the property. Nothing we could do about it.
Why does it matter the extent of the system on that property where your client could be charged with the knowledge that the Powers property was employing a drainage system on your client's land that was draining their property?
Because of the fact that we're talking about a pipe through the property. That's what we're talking. We're not talking about draining into the property. We're talking about a pipe, which no one knew about, and now which they're spending $50,000 to build a new one. That's the point. And
Attorney Earhart, Attorney Earhart, let me just make sure I'm understanding this part of your argument. If I am, I think what you're saying is that your client was properly charged with the knowledge that what is called in this litigation CB1 was on her property. That she's properly charged with the knowledge that the Powers wetness was draining into CB1 on Ms. Weeks' property, but you're taking issue with the fact that instead of just pouring water onto the mutual driveway or onto Ms. Weeks' property, CB1 drained through an existing vitreous clay pipe. Is that the nub of your concern? That
is correct. No one knew that pipe existed, and that's what's been replaced. It's cost $50,000. They redone a whole drainage system, put a whole massive pipe system in. It's not just a clay pipe like a flower pot anymore. It's PVC. It's a massive thing. It goes all the way down the street because it couldn't cross the street. Instead of a little pipe going to her driveway, it's now a massive thing. But more importantly, that pipe was unknown, and that's what we're fighting about. If they want to drop their water into the groundwater on that drainage pipe, fine. But they're trying. In fact, what they've done is they built a whole new pipe, and they've changed the location of the pipe. They've driven it down the road, and they hooked it into a way down the street, and they crossed the street. Substantially different. And more importantly, she didn't know the pipe was there. No one knew the pipe was there till all of a sudden, July of 2017, we had flooding onto her property.
And when you say no one knew the pipe was there, Attorney Earhart, are you talking about the vitreous clay pipe that is entirely on your client's property?
That is correct, Your Honor.
So can I switch gears a little bit and say the way this case played out, it appears that the parties considered the prescriptive easement issue a threshold issue, and that the trial on the cost sharing and the tort claims and damages sort of depended on that.
That's correct.
Is
Yeah,
that,
yes.
but I'm having a hard time coming to the conclusion that is necessarily true, regardless of whether or not the powers held in prescriptive easement. Aren't there still, for example, cost sharing issues? If people are jointly using a drainage system, there may be, whether it be unjust enrichment or something else. And I would add that, while Massachusetts used to be what's called a common enemy state on groundwater discharges, surface water discharges, it no longer is. Rules of negligence and reasonable use of property apply. So I'm confused about why the parties necessarily assume that they had to prove a prescriptive easement, and beyond that, I'm frankly confused about what you're arguing now, because while you're contesting the correctness of the judge's ruling that there was a prescriptive easement, you at the same time acknowledge the new reality that the new drainage system is there. You don't seem to be contesting the imposition of the easement, but you then now claim that what you're really seeking is compensation for that. So how do you get to pivot?
Here's the pivot, Your Honor. That was litigated and it was built. We're not going to tell someone to take out $50,000 worth of drainage, okay? But the point of the matter is they stole an easement. They shouldn't have had it. They've got it. At this point, our remedy is not to say no easement, go back and have your pond. But no, what we're saying is at least go remand it to the lower court to find out. There's a $2 million in the estate and they got a bond even because we asked them for an attachment. So we know that they can cover the cost. Have the lower court find out if the powers at the beginning, when this all started, we wanted them to pay for a lot of stuff. If they had agreed to pay for the easement, what would the cost have been? What would have been a fair market value for that easement? That's this point. That's what we can't unring the bell. It's there. It's done with. So at this point, you're right. We're looking for to reverse it and remand it to give us the value of whatever that easement was to the powers property. Does that make sense, Your Honor?
It
No,
does
I
make
understand
sense.
that. Go ahead.
Are you still going?
Yes, I am.
I meant Justice Milkey, but that's okay. We're all still going. I guess the part of that I'm not following, Attorney Earhart, is if, we all remember from law school, which may have been a long time ago for all of us, but for a prescriptive easement, you only have 4 elements to meet. And it sounds to me like you have admitted during this argument that all 4 elements were met. So I'm having some trouble.
Not initially, Your Honor. At the beginning, that's what we're saying. It was partial summary judgment on the part of the estate. We opposed it on the grounds that there was no prescriptive easement because it was not open and notorious. No one knew that pipe was there. And the fact that there was a drainage built that drained the property doesn't make that open and notorious. The judge says it's a close call and I decided it's open and notorious. And she should have known about it reasonably. You can't just sit on it, on your rights. But the fact of the matter was, that's a very, very slight basis to say that she knew there was a pipe there. Clearly, no one knew that pipe was there. And to say that because drainage was at the bottom of the Powers driveway somehow said there was a pipe, it was not open and notorious. That's what I'm trying to say, Your Honor. It should not have been granted. It's been granted, and we are limited now on our remedy. Does that make sense?
Yeah, we understand what you're arguing. Let me just ask a question. Now I've forgotten what the question was. The jury, apparently, we don't have the transcript, but the jury apparently found that what the percentage of appropriate cost sharing was based, I take it.
The judge's instructions.
Yeah, on the instructions, which we don't have. But the jury appears to have determined that your clients are substantially benefiting from the new drainage system that was installed. you appear to be arguing that this never should have gone to the jury because of the prescriptive issue.
That's correct.
Putting that aside, we have no basis, do we, to question the jury's verdict and your client substantially benefits from the new drainage system.
Your Honor, we cannot, we would dispute it, but if it's jury verdict in the story, we're stuck with that. And, you know, we're not, you are a court of law. Right? But the real question for that issue is not the allocation by the jury, because they had no choice in, but the judge has allocated and they made their decision. Our argument is that the judge, in her own opinion, said that the usual rule is that the owner of the dominant estate maintains and repairs it. But she felt that if the SJ, and it's in the record, I believe, Your Honor, that I cited to you, that if the SJC were to review the issue anew, it would adopt the restatement of property third servitude section, which says that when you have a easement that benefits both parties, they should share the cost based upon the reciprocal benefits. And in our brief, you see where I'm coming from now, Your Honor? In our brief, we're saying you should not adopt that, in which case the issue of whether the court's allocation would be inappropriate, because that's not, that was not what the...
Don't you have to challenge the jury instructions in order to preserve that issue? The jury wasn't even given the issue as to whether that should be the law. They were just told. No, the jury was instructed as to what the law was. We frankly have little idea of what the jury were instructed, given that we don't have the transcript. I'm assuming you didn't challenge them, but I don't know.
The question is this court, however, has to make a decision of law as to what should be done in this case. It's a question of law for this court to decide. The judge, in her opinion, which we cited, we attacked the judge's opinion, irrespective of the allocation. We're saying the judge's opinion, in which because we went for partial summary judgment, Your Honor, and we're appealing the denial of our partial summary judgment on this issue. We're not going to.
Frankly, you don't get to do that.
Huh?
You don't get to do that. You can't. That issue is moot. The question is what happened at trial and whether or not this issue was preserved. But I'm going to have to bring this to a close unless either of my colleagues has a question.
Can I just mention the last one, Your Honor, on the question of the 20,000 negligence, but there's no proof of the judge herself says there's no evidence of damages. The judge said that without damages, you can't grant $20,000 to for negligence when there's no, the judge says there's no evidence of damage.
Okay, we understand the argument, counsel. Thank you very much. We will now hear from Attorney Parker. You're on mute, by the way.
Can you hear me now?
Yes.
Good morning, Your Honor. This case is complicated, as you've pointed out several times, by the absence of a transcript. Dealing with the first issue of the summary judgment declaring a prescriptive easement, were the Superior Court Rule 9AB5 statement included in the record, the appeals court would have all of the information that was before the judge. That information, in the absence of that information, we're forced to recite things that are not before you. Mr. Earhart's description of the common drainage system is just not accurate. There's a stream.
Counsel,
I'm sorry?
You understand, though, that we could call up the summary judgment record ourselves. The rule is that we don't have to.
Well, were you to do that, you would find that there's a stream that runs behind the houses on Meadowbrook, that runs and intersects with the Powers property, and runs behind the Powers property and behind the Weeks property, and around and down into the street. And that stream for probably, and the testimony is clear in the summary judgment record, that stream was channeled through a system of pipes for more than 70 years. So this is not something that just happened in 1985, but it was there. The pipes, the vitreous clay pipes, were identified by the engineer as being at least 70 years old. And that corroborates with the development of the subdivision, which was land owned in common. Again, all of this is in the B5 statement. The land was owned in common back in the 1930s. And so that system channeled the water underneath both Powers and Weeks property and around and out into the street. In the mid-'80s, it was rebuilt by Powers. They put in another pipe to collect the stream water and ran it to CB1, which is in the northeast corner of the Weeks property. If one looks down into CB1.
Okay, counsel, I believe my colleague, Judge Massing, has a question.
Oh, I was just
Sure.
actually, I was trying to visualize it. So the CB1 is the one that's between the two properties?
That's correct.
Okay, and
It's in
CB2 is the one on the other side of the Weeks' property?
That's right.
Okay,
CB2 is over on the other side.
Okay.
So if one were to look down into CB1, I mean, you can do that today. If you walked over and just looked down, you can see the water, the stream water coming in from one pipe and going out through the other older pipe, the vitreous clay pipe. And if you look at it, the direction of the pipe, and you can do this from standing on the ground. If you look at the direction of the pipe, you can see it going over towards the direction of CB2. And if you walk over to CB2 and look down in that one, you can see the water flowing in. Now, that was the common drainage system that was there since '85.
And so
and I
your
think
position, sorry, Attorney Parker, just to put a legal point on that. So your position is that the Superior Court's decision that the open and notorious aspect of the prescriptive easement test is met by that even if Ms. Weeks didn't actually walk over and peer into the catch basins as you described, she could have, and therefore she was on notice. Okay,
Right.
thank you.
And that notion is reinforced in the case of Foote versus Bauman, which is a much older case where a line had manhole covers in it. And the court said that the manhole covers were an indication that it was open and notorious, that the line underneath was there.
Foote was not a summary judgment case, correct?
I'm sorry, Your Honor?
Foote was not a summary judgment case, correct?
No, it wasn't, but it elucidates the principle of open and notorious in terms of what kinds of indications on an underground line would indicate that it was in fact there and operating.
It
Counsel,
does, though. Oh, go ahead. Sorry.
No, I was going to change subject, so you go ahead.
Well, I wanted to say my memory of Foote, which is always suspect, is that not only were there manhole covers in that case, but there was actual regular service of the system as a whole. Is that right? So that's a little different from this.
That's absolutely correct. That was another factor that the court pointed to that supported the open and notorious conclusion.
And just on the factual issues, the lawsuit began because there was a backup at CB1 and it starts flooding both properties from there. Is that right?
No, actually, Your Honor, the backup wasn't at CB1, but that on the Weeks property, about 120 feet from CB1 to the west, the vitreous clay pipe collapsed. This is just a clay pipe that was 70 years old or more, and it simply collapsed in two locations. And that's what caused the flooding of the backyards of both properties. There was nothing there was no, nothing in
Okay, okay.
CB1 that caused that.
So it's flooding in the back there where the pond used to be, and it's that caused that brought this to a head.
That's right. And the properties, Weeks's property is actually a little lower than Power's property, and so it suffered most of the flooding. And the notion that Mr. Earhart raised that Weeks could have thought that the water just drained through CB1 and then seeped into the ground is just not supported by any kind of scientific evidence at all. In fact, it's belied by the fact that after the blockage occurred, the backyards flooded and stayed flooded until such time as the blockage was replaced.
Counsel, I'm just going to switch gears slightly. Do you agree with my characterization that the litigants and the judge, I can't remember, it was himself or herself? Herself. Dealt with this case as if the prescriptive easement issue was a threshold issue on which the cost sharing and the other damages portion of the case depended?
I don't think depended is the right way to conceive of it. The Weeks refused, the properties were flooded in July of 2017, and Weeks refused to fix the blockage. And she also refused to allow the estate to come on the property to fix it, even when the estate offered to pay the cost of doing that. And so we were stuck, and we had to go into court to get authority to go in and fix it. And the estate initially argued that we had an easement by implication because this thing was so old. It was 70 years old at a time when the property was held in common ownership. And we also argued the prescriptive easement because in 1985 it was repaired, and Weeks had admitted in her affidavit that she refused permission to have it repaired. So the court ended up finding a prescriptive easement, not the easement by implication.
But I mean, I'm wondering why this couldn't have been pled differently in terms of just reasonable use of the property and unjust enrichment and a whole number of other potential claims.
Well, it seemed as though that this was an easement by implication that arose in the development of the subdivision in the 30s. I mean, you and I both know that the rules of law change, but one rule of property development by realtors is they don't want to give up any lots unnecessarily in a subdivision. And I think this system, I think there was every evidence to suggest that this system was installed back then in the 30s in order to drain the stream around those two and make those two lots buildable. There was never any record of any written easement. The town had no records or anything else. And the estate was in the position of trying to resolve its assets and sell the property. And the only way we could do that was to fix the system. And so that's why we asked the court for the right to go in and fix the system. It was nothing.
It is an unusual case where all the action in the ground happened through some kind of interim order, allowing someone to come in and build a $50,000 system on someone else's property.
Well, there was already a system there. We didn't build a new system. We just replaced the pipes that were blocked. And it turned out
by the way, the partial summary judgment determined that there was a prescriptive easement, but the new system that was put in a somewhat different location on the Weeks property. Was there any formal MPM management kind of hearing in terms of the relocation of the easement?
Yes, the judge, the judge acted in two parts. First, she found that there was a prescriptive easement and a right to fix the system. And then she had a separate hearing in which she reviewed the plans for the repair of the system and issued an order saying that those plans were reasonable. It's
No,
interesting.
but that may be somewhat different than convening a hearing on the relocation of the easement, applying the MPM factors and so forth. Did that issue get litigated other than geographically where this should be located?
Well, I don't, the issue was litigated in that hearing. Both sides were given an opportunity to present oral and written testimony in the second hearing. And the only reason that we moved the pipes at all was that if we put them in the same place, they would have had to take down a deck on Mrs. Weeks' property, her rear deck.
Yeah,
Go
most
ahead.
of this is not in the record, so I don't really
That's
want to
right.
go.
Well,
don't really
that
wanna go
just
there.
points
I
out the
want to
difficulty.
give you an opportunity to respond to the last argument that your brother argued with respect to the judges making a comment that he characterizes as there was no evidence of the tort damages, but he's going to let the jury, or she's going to let the jury verdict stand anyway. That's the characterization of it. How do you respond to that?
Well, that characterization is not accurate. The judge did say there was no evidence of damage in the loss of the sale of the property or in the diminution of the sale of the property. But there was damage, there was evidence of damage in the $53,000 that it cost to repair the blocked pipes. And the jury was asked to allocate the benefit that the system provided to both properties. And the jury did find 65-35, as you pointed out earlier, based on the size of the properties and the drainage. The testimony of the engineer was that both properties benefited from the diversion of the brook. The groundwater was the other thing that was drained off, and that was mostly from the Weeks property. So the jury could well have found that they did find, in fact, in the verdict slip, that Weeks acted intentionally and recklessly in denying the estate the right to come in and fix the line.
But what basis, were we to have the trial transcript before us, what basis would we find to support the $20,000 component on the damages issue?
Well, if you do the math on 53,000, 65% of it and 35% of it means that the estate would be recovering just $32,500.
No, I understand the cost sharing aspect.
And so the jury, a reasonable jury, if I may just quickly finish, a reasonable jury could say, well, we're going to award the estate another $20,000 to make sure that the estate is at least recompensed for the $52,500 or $53,000 that it cost the estate to fix this. Because Weeks is the one who had the blockage on her property and didn't act, and kept the estate, having enforced the estate to go to court in order to act. Okay. So a reasonable jury could tag Mrs. Weeks for that balance, that $20,000 difference, which is exactly what they did.
Okay, now returning just very quickly to the issues of the new owner and this relation to the case before us. Do you agree with the characterization that the point of the easement on the Millett property, what is now the Millett property, was for her benefit with regard to rights in the Weeks property, not a burden on her own property?
That's totally correct. The order of the Superior Court in Hampden County only applies to the Weeks property. It doesn't impose any obligation on the Powers property whatsoever.
How does the easement get filed post closing without Ms. Millet's apparent knowledge or consent?
Well, she did have knowledge and consent because she was represented by an attorney in the closing, and the attorney raised the issue of the judgment and the litigation, and I sent them copies of the final as-built plans. They knew all about the litigation and the order of the court, and the fact even that nothing applied to the Powers property. There was no.
Okay, but last question, at least for me. Has the easement been filed on the Weeks property?
Oh, the judgment has. The court went through several iterations of judgments. I think there were actually 3 altogether before the court finally settled on a judgment.
Well, it appears there are still 2 separate judgments, but.
Well, that may appear that way, but I know that we went through 3 iterations of trying to get the judgment right. And the court finally had one which was the subject of this appeal. That judgment has been made of record. But that judgment, again, Your Honor, only burdens the Weeks property, giving the Powers property the right to continue a repair.
Okay, do either of my colleagues have any follow-up questions? That concludes the hearing with the one qualification that I just want to say to both parties. Some interesting issues have been presented to us. We will do our job in resolving them, and we will likely do so relatively quickly. I'm not going to, I've been around the block long enough to know that I'm not going to try to apportion faults in terms of what happened here. But I can say, I think, with the backing of our panel, that if ever a case should have settled a long time ago, it is this case. And I realize this is unlikely to happen, but either before or after we issue our ruling on this, I would encourage the parties to keep talking to try to resolve this, because for any number of rather obvious reasons, this was a case that, again, should have settled a long time ago. And with that little speech,
Okay, we are live and recording.
thank you very much. We are back on the record for our third case of the morning, and that is Green versus the Whiting Turner Contracting Company, 2021 P597. Our usual rules apply in terms of 15 minutes per side, no opportunity for rebuttal. We remind the parties we have read the briefs, so we're familiar both with the facts and the arguments. We therefore ask that you cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Albano.
Thank you, Your Honor. May it please the court. My name is Mark Albano. I'm an attorney in Springfield who has the privilege of representing this morning the plaintiff, Richard Green, in this personal injury action against the defendant, Whiting Turner Construction. The case involves an appeal by Green from the grant of summary judgment on statute of limitations grounds entered by the court, Superior Court, by Judge Hodge under Rule 12. Because this is an appeal from a dismissal under Rule 12, the court's review is de novo. In essence, and to cut to the chase, the court in this case must resolve whether the Massachusetts Savings Statute, General Laws, Chapter 260, Section 32, applies to this action and thus would serve to bring Green's claims within the statute of limitations. As pertinent, only the pertinent provisions of the savings statute provide 1 year for refiling any suit dismissed for either, quote, insufficient service of process by reason of a default or neglect of the officer to whom such process is committed, close quote, or quote, for any matter of form, close quote. It is Green's position that he has shown in this case that he is entitled to relief under both of these components, although either would be sufficient.
Okay, counsel, just to clarify, you are not the counsel who missed the deadline, correct?
Unfortunately, Judge, I am and was. Yes. If I may direct the court's attention, this is a construction accident. Green, then 53 years old, was an iron worker working for a subcontractor on a public works contract at the University of Massachusetts in Amherst. He was injured when a piece of structural steel fell upon him. As of 2020, the workers' compensation lien is in excess of $335,000. So it's a significant case. The accident occurred on June 9th of 2016. The original action was timely filed on June 6th of 2019. Under Rule 4 and the long arm statute, service was required to have been completed by September 4th, but it wasn't completed until 13 days later on September 17th of 2019.
Attorney Albano, can I interrupt you just for a minute with a question about the record here? In reviewing the cases on the savings statute, one of the things that keeps coming to the fore, at least for me, is that if service is actual, in other words, if the other party has been put on notice in some way, even though service itself may have been delayed, that it's a factor the court can consider. I looked through the record here and I don't think that I saw any evidence that Whiting-Turner was on notice, on actual notice as opposed to service notice in a timely manner. But if I've missed anything in the record, would you please let me know?
Yes, Your Honor. There is no indication in the record that Whiting-Turner was on actual notice prior to being served on September 17th, 14 days late. It is Green's contention, however, as set forth in his principal brief and in the reply brief, that the actual notice requirement is something that is not required by the savings statute. There's no requirement or no mention of actual notice in the state savings statute. And it's really, it arose from the dicta, I think, it traced in my brief. And it's Green's position, again, that because the statute is a remedial statute and because there's no actual notice requirement set forth in the statute, the court should not amend the statute by imposing an actual notice requirement. Fine.
I understood. No, I did understand you to be making that argument, though. I think to some extent it's sort of neither here nor there in this case, where it sounds like there is no actual notice that is at issue. So turning to those cases, I mean, I think one of the cases you cite and one of the cases I'm very interested in is our decision in the Halsey case. And I guess it's difficult for me, at least without your assistance, to square that decision with what you're asking for here. Halsey says that a failure to provide a defendant with notice is a matter of substance, and you are arguing that in this case it's not a matter of substance. How do you square your argument with the Halsey decision?
Judge, the only way I can square that argument is to make the argument that I made, and that is that actual notice should not be required under the statute. And actual notice issue pertains only to the second component of relief, and that is for any matter of form. So even if Halsey is correct and actual notice was required, it's Green's position that he's entitled to relief under the first component, that is that there was insufficient service of process by reason of default or neglect of the officer to whom such process is committed. And that officer is me. As an officer of the court, I undertook to effectuate service under the long arm statute by placing or obtaining the summons, preparing it, placing it in the mail by certified mail. And again, it was 13 days late. There's no doubt about that. But clearly there was default and neglect by me as an officer of the court in effectuating service. And it is Green's position that the statute is remedial, that it is intended to have cases decided on their merits and not on technicality, and that the motion judge should have allowed relief under that provision of the statute. And
well, let's explore that a little bit for a moment, if you don't mind.
Sure.
You say that you were acting as an officer of the court when you undertook to effect service under the long arm statute. As a trial lawyer, is there any time when you are not, and not any time, is there any part of your practice in which you are not acting as an officer of the court?
I would say, Judge, no. And for that proposition, I would direct your honors of the court to the case of Henry Romes, which is cited in my principal brief, which is a 2010 Supreme Court decision, SJC decision, in which they defined the role of an officer of the court as a role which encompasses directing and managing the enforcement of legal claims and the methods to be adopted to enforce those claims. And I would suggest that as a trial lawyer, certainly affecting service, which is required under the law, and doing so under the long arm statute and under Rule 4 is certainly sufficient in light of the remedial purposes of the statute to allow application of that provision.
So assume for a moment that we were thinking of agreeing with that proposition. Let me see if I can formulate this as a decent question. Would there be any time where an attorney could not excuse late service under the reading of this provision that you are now proposing to us?
So long as the attorney attempted the effectuation of service in his role as counsel, I don't think so. I had difficulty tracing the legislative history of the saving statute, but it appears that it was on the books in 1786 and has gone through iteration since then. And certainly back in the 50s, when there were cases decided which didn't require actual notice, but that's beside the point. The only way to effectuate service was to place process in the hands of a sheriff or a constable, i.e. an officer. Attorneys only became involved effectuating service in 1968 under the long arm statute when it was adopted in Massachusetts. And then in 1974, when Rule 4 allowed for service by certified mail upon out-of-state defendants.
And so would you agree then if we found ourselves to be a panel of originalists, which I don't think is likely to be an outcome, that the term officer in the savings statute, at least as originally understood by the drafters of that legislation, would have meant someone that we would all consider traditionally an officer, a sheriff or someone of that nature?
That's correct, Judge. Because I don't think there was service back then by anyone but officers. But with that, again, it's a remedial statute.
Hey, counsel, on that note, I'm going to ask an indelicate question, and my apologies for doing so, but I have to ask it. Your argument is basically this is a remedial statute, and darn it, your client should have a remedy. Why isn't the obvious remedy sufficient? It's just the party in interest wouldn't be the construction company, it would be your own insurer.
That's correct. Because again, it's a remedial statute that is intended.
No, but my question is, and I apologize for being flip about it, but I don't think I made my point, which is, isn't this why God invented malpractice cases?
I suppose it is, but I hearken back to the application of the statute and its remedial nature, not to have plaintiffs make malpractice cases against their attorneys, but rather to have their day in court on the underlying claim, because a malpractice case against an attorney isn't as good as the underlying claim that a plaintiff would have.
Why not? You still have the case within a case.
It is a case within a case, but his recovery is limited. It's more difficult to get an attorney. It's really not something that is analytically appropriate within the confines of the savings statute, which is really, ultimately, we have a complaint that was timely filed. We have substantial claims alleged. We have a serious injury. We have a dismissal originally without prejudice. We have a 13-day delay in service. We have no allegation or proof of prejudice by the defendant in the 13-day delay. And we have this case, which was timely filed within 14 days of the dismissal of the original claim. In light of the purposes of the statute, and it really, Judge Gertner in her decision, which is cited extensively in my brief, really goes through the analysis as to why the savings statute should mean what it says. And unless there are other questions that the court may have, I would yield whatever time I have left to the court.
You have 22 seconds.
Well, too well.
Do either of my colleagues have any follow-up questions? Thank you very much, counsel. We'll hear from Attorney Stanton.
Yes, thank you, Judge.
Good morning, Your Honors. Robert Stanton for the appellee Whiting Turner. The issues, I think, are very simple, very straightforward in this case. Essentially, there are two grounds that the appellant is claiming that his underlying action should be permitted to be saved, that being the dismissal due to insufficient service for default or neglect of the process server, as well as for any matter of form. I think before even getting to whether or not counsel qualifies as an officer pursuant to the terms of the statute, I think it's instructive to look to some of the cases that are addressed, even going back to the 1800s, which consistently throughout, even if they permit refiling or reject refiling pursuant to the statute or its predecessors, note that due diligence and a lack of neglect needs to be demonstrated by the party seeking to refile. For instance, the Cumming versus Jacobs matter indicates that the purpose of the statute is not to relieve a party who acts in diligently and is not intended to encourage default or neglect by the plaintiff or plaintiff's counsel. I think that carries through to the Negron v. Dozier case, which an appeals court case from 2011, which on an issue of a motor vehicle accident, which was filed timely, was not served timely, was dismissed due to lack of service, was refiled under 260 section 32, was subsequently dismissed again. The court noted that simple attorney negligence does not constitute grounds for permitting refiling.
That's an unpublished decision, Attorney Stanton, is that right?
That is correct, but it speaks to the holding in Krasno, the 1990 decision, which is not an unpublished decision, and directly applying it to the facts of that case. As to the issues as to whether or not officers or counsel qualifies as an officer under the statute, referencing that times have changed since the 1800s in terms of who would have been intended to serve process. There are cases from the 1990s, from the 2000s that continue to hold that the officer cannot be counsel, which I think falls in line with the proposition that counsel or the plaintiff themselves cannot be negligent in prosecuting their case.
Counsel, would you acknowledge two things? One, that there is no reported appellate case on point. And two, as a matter of just pure linguistics, there is a basis, not how the statute should be interpreted, but there is a basis for interpreting it as your brother suggests. Again, just pure linguistics.
As to your first point, Your Honor, I think the Krasno case is as factually similar as you will get a case that was dismissed for lack of proper service and was refiled and was dismissed again. And the dismissal was affirmed, and being that there was not proper service, and that would be the closest factually reported case. I would agree with Your Honor on that sense. As to the second issue, I think whether or not my brother should be considered to be an officer of the court, and the statute could be read that way. I think there are issues with reading the statute that way.
No, I understand that, but pure linguistics.
I think that from a linguistic standpoint, I think officer is a broad term. However, I do think that there is a clear indication in the statute and the interpretive case law that
I think that's the most I'm going to get.
I think it's clear that the officer is supposed to be a third party to whom the plaintiff cannot control, someone outside of their control who errs in service as opposed to their own counsel. I think, again, the interpretive case law going back to the 1800s indicating that there cannot be negligence or lack of diligence of counsel speaks directly to that point.
Well, let me follow up on that, Attorney Stanton. I apologize in advance for being relatively inarticulate because I have been unsuccessful so far in articulating this to myself in any reasonable way. But I did wonder, reading the case law, whether that third party piece is sort of an unspoken through line in the interpretation of this savings statute. In other words, if there's some perhaps assumed or unspoken part of the savings statute that has to do with saving a party from the actions of someone that outside of his or her control, and that to the extent that counsel is the direct representative of a party in a legal proceeding, that counsel wouldn't really qualify, but that, for example, if a sheriff to whom the process is entrusted, has an accident with their horse on their way to serve the defendant, that's something that you really can't hold the defendant responsible for in some sort of equitable way. Does that complete mess of an inarticulate description resonate with your reading of the cases or the history at all?
I think that is a more accurate reading, Your Honor, because, if it's one thing, going back to those interpretive cases, they do articulate that there needs to be diligence of counsel, diligence of the plaintiff themselves. And so that would suggest or speak to the fact that a third party to whom they could not directly control, as Your Honor referenced, would be a party that they may be able to seek some benefit from or some relief from the negligence or default of that party, excuse me. And that again goes to, there may not be a right of addressing that negligence or that default, whereas there may be under the other circumstances that, that may be pertinent. As I sort of mentioned in my brief and as was discussed in the lower court, I think it's quite clear that, again, your service or the officer to whom you're entrusting service is that person whom you give the process to be delivered. Under the circumstances of service within the Commonwealth, most often an officer being a constable or a sheriff outside of the Commonwealth, it's not as if someone is actually, either the plaintiff or their counsel is actually making the delivery upon a defendant themselves. They're entrusting that delivery to another entity, to another individual, that being the Postal Service or some other process server outside of the Commonwealth. I think that, the body of interpretive case law running back through the period of time, as well as even the persuasive, though perhaps not reported opinion in Negron v. Dozier, speaks to the fact that simple attorney negligence or neglect of counsel is not sufficient grounds to permit refiling. As to sort of the second issue that is raised by Mr. Green as to whether or not this is a dismissal for a matter of form, I think it's quite clear throughout the case law, both Halsley, Negron again, Krasno, that a dismissal for improper service or insufficient service under Rule 4J constitutes a dismissal for substance as opposed to form. It's quite clear as you look at the interpretive case law on this issue, particularly the Liberace opinion. It discusses how there was a change in the interpretations and the modern interpretations and discussion of the statute and application of this issue do require actual notice to a defendant within the limitations period. As counsel alluded to during his argument, there's nothing in the record here that suggests that there was any actual notice to Whiting-Turner within the limitations period. And, there wasn't any notice to Whiting-Turner until the date that service was effectuated, which was outside of the 4J period and subsequent to the elapsing of the statute of limitations. Finally, just as counsel raised the issue of prejudice, there's no discussion in any of the case law about timing that cases need to be filed or prejudice to the defendant. I think it's even more notable when you look at the issues in Gifford, the Supreme Judicial Court decision cited in my papers. On the same day that case was dismissed, it was refiled, and the court held that there being no notice to the defendant within the limitations period, it couldn't be saved pursuant to 4J, pursuant to Chapter 260, Section 32, as well as the Krasno case was refiled within 10 days of dismissal. Still, there being no notice within the limitations period, it wasn't permitted to be refiled pursuant to Chapter 260, Section 32. Both time periods are shorter than the time period at issue in this case in terms of when the refiling occurred. Neither case discusses whether prejudice is an issue whatsoever. The sole issue is whether or not notice was effectuated with it or was made upon the defendant within the time period.
Counsel, doctrine aside, how do you address the basic fairness argument that from the plaintiff's perspective, he was seriously injured? For all we know, he has a valid claim against your client. He entrusted service to someone who, for some purposes, is an officer of the court, and yet he finds himself out of luck. What's the answer to that? Again, doctrine aside.
Sure. I think even noting the papers, Your Honor, it's not as if Mr. Green is completely left without sort of recourse in this case. Moreover, even looking at some of the facts alleged in counsel's brief and as discussed during his argument, Mr. Green was recovering, I think, workers' compensation for these injuries. It's not as he was left not being whole or not made whole in some way, shape, or form. He's been able to obtain some compensation for those injuries from a statutory mechanism that's put in place in the Workers' Compensation Act. Further, I believe there are, as Your Honor articulated, there are appropriate measures for which he can seek relief. Those just may not be against my client under the circumstances of this case. While there may be a preference for matters to be litigated or adjudicated on the merits, it's not an absolution that matters be adjudicated on the merits. Certainly there are circumstances, statute of limitations being one, in which cases are not adjudicated on the merits due to some violation of court rules or statutes. Very simply, while there may be a preference, it's not an absolution. This is one of those circumstances in which that preference, unfortunately, for the plaintiff may not be reached. But as I mentioned, he does have some methods of recourse and has been compensated for some losses, at least due to his workers' compensation recovery. If the panel has no further questions, I would just rest on my briefs.
See, members of the viewing public, that we have been unable to get one of the attorneys' video to work. He will be participating through his phone feed. And with that, we will call the case. And I just want to note that we have read all of the briefs and the record, so we're familiar with both the facts and the arguments. So I would urge counsel to cut to the chase to the extent possible. So with that, Attorney Joubert, the floor is yours.
Thank you, Your Honor. May it please the court, my name is Attorney Mark Joubert, and I'm counsel for the appellant Joseph Cotrona. The central question before the court is whether or not the employer violated Mr. Cotrona's due process rights specific to Rule 34 and the subpoena documents that we were requesting on at least 2 occasions. And they're relevant to the either the support or the contradiction of employers' claims that appellant not only removed client's property, but that the appellant actually ordered the items in the first instance. And we were hoping to get, and specifically in the second subpoena, we're requesting surveillance camera footage, the history of laptop access relating to vendors, and the company issued phone records, as well as their counsel.
Counsel, it's I think you can see me. It's Judge Milkey. I'm confused about one aspect of the facts, and that is both sides seem to acknowledge that some of the material was within the control of the client.
Yes.
I'm just confused by that. Perhaps I don't know this industry, but
no, it's confusing. I can clarify that.
If you can shed some light on that, it'd be helpful.
I surely will. Charles River Laboratories, at some point several years ago, they had their own maintenance department, and they thought it would be better for them, a business decision, to hire a third party, an outside source, to conduct their maintenance needs. So they farmed it out to ABM Industries Group, and they became Mr. Cotrona's employer. He had previously worked in the Department of Maintenance for Charles River Laboratories, and they are called the client throughout the pleadings and documents, whereas the employer is ABM Industries Group, if that's helpful at all.
No, it's extremely helpful. Can I ask though, can we just go right to the preservation issue? Because I understand that, the issue came up a couple of times in terms of what your sister sort of, I can't remember exact words she used, but it's like there were complaints about the lack of receiving the information. But don't you, in order to preserve the issue, have to make formal requests at that point in terms of sanctions and such, or at least, employ the court process of compelling the production of this? How is it that you can say, oh, well, you know, darn it, we should have had this stuff. And then on appeal say, oh, and our due process rights were violated, even though we didn't do anything to press the issue.
Thank you, Your Honor. Thank you for helping me focus. I did at the Department of Unemployment Assistance make that very comment to Mr. The hearing officer, Eric, I think it was named Johnson. Anyway, I made that to him several times, and he said, both in the hearing and outside the hearing, in the presence of the other attorney, and he told me that there was no mechanism for a motion to compel in his understanding of the process on his level, the agency court. But I did mention it many times. It came up. We spoke to the human resources manager, Connie Stager, offered many times, several times, I wouldn't say many, at least two, that she would do her best to get that information. In fact, she had brought with her a CD with videotape from just 2 hours earlier from what I was looking for with regard to rinsing off the vehicle in the boiler room area. And it would be probably on the same roll. According to Ms. Stager, every exit door was fitted with or above it, was fitted with a surveillance camera. So I wasn't asking for an overly burdensome thing, because the testimony of their chief witness, who was the assistant to Mr. Cotrona, claims that he physically saw with his own eyes, Mr. Cotrona leave the building with these pool anchors that allegedly Mr. Cotrona had in his possession and had Mr. Ebeling hide under his desk, et cetera, et cetera. So,
Well,
yes,
Mr. Attorney Juber, I'm sorry, let me, I hear you moving into a different part of your argument, and I do promise you that you will get there, but I would like to, I'd like to dwell for just a moment on what Judge Milkey was asking about, which is the record on your spoliation claim. And I apologize because I'm not familiar with the practice before the DUA. So this is a legitimate question, not one that's designed for some kind of purpose of trapping you. But is there, well, let me start with a basic proposition. Having reviewed the record, it is evident to me that Ms. Stager testified at a number of different points during the hearing that the items that your client sought were not things that she had access to, right? And I think we've talked about that today. They were in the possession of the client. Am I right to understand that?
Well, yes and no, Your Honor. She did have access. She tasked a man named Mr. Raymond, who was one of her witnesses who didn't become a witness. He was in the queue. We had Zoom meetings, and he decided to leave it. And but anyway, she tasked him with doing the research of collecting surveillance footage, and he was in her control. He asked her to do it. She could have easily asked him to grab another camera's footage. So it's not accurate for her to say she didn't have control when she had somebody.
Stop. I want to drill down a little bit on that. It sounds like she requested a video, at least, or the person she asked to get it did, and it was provided. That does not in itself say that she has control. It may say that the client was cooperative in this respect to that request, but uncooperative for other requests.
Thank you, Your Honor, again. Mr. Raymond was working. He's one of the employees under Mr. Cotrona's control. He was one of his subordinates, and he was not working for the client. He was not related to the client any more than Mr. Cotrona was. He was with the maintenance company and an employee of ABM Industries Group. So,
but counsel, do we know how he obtained it? Did he retrieve it himself from the cameras, yes, or did he request it from the client?
No, Ms. Stager said that he did it. Mr. Raymond was able to obtain it, not the client.
But we don't know how he obtained it, do we?
Yes, we do. She said he reviewed it himself, and it took hours for him to find it and do this type of research.
But that may be because the client provided him access to do so, correct?
My understanding at the time, and what you're saying, I understand, and that could be true, but I was led to believe that he was doing research for her to help find the truth, so to speak, of this case. So I don't know if he was seeking the client. There was no testimony where he was requesting from the client access to anything, but that he was on his own able to do that. That was the implication at the time, and hence the hearing officer made note of that, and note that the client, when the client didn't want to involve itself, he says it speaks volumes. But that was after we had obtained from ABM the footage that ABM was able to glean and collect.
And so during this DUA process, is there a mechanism by which your client or someone in your client's shoes can subpoena a third party, in this case, the client itself, Charles River?
We sent to ABM, and I'd have to look at I said, no, I don't know that. I asked the department, the hearing officer with the DOA, and he said, we have no other mechanism. This is how you would send it to the employer. So that's what I did. I sent it there. We had a scheduled date. We had plenty of time to get it, and it just never appeared. We spoke about it at length during the 4 sessions, and we were promised it. And then ultimately, Ms. Steger said the client is unwilling to give us any more.
And I guess that's what I'm trying to get at, right? Because I can ask you until the cows come home to get me something from Justice Milkey's office. But if Justice Milkey won't give it to you, it doesn't really do me much good. So that's, it came up obviously through the course of the hearing, through Ms. Steger's testimony, that the materials your client was looking for were not in her control. And I agree that, clearly the record shows that she endeavored to get them and was successful in getting some of them from the entity who controlled them. But fundamentally, if you are asking for something from the wrong person, I'm not sure what that does to your spoliation argument.
Well, she claimed to be the right person in the beginning. And if I had known from the beginning that she would be unable to obtain what she said she could obtain, I would have done exactly that. And I'm sorry, Your Honor.
No, I was just going to say, but getting back to my earlier question, putting the subpoena issue to one side for the moment, shouldn't you have then said, okay, since we can't get the information, I'm asking for sanctions, for example, Mr. or Mrs. Hearing Officer, please exclude the testimony that I was observed to take this, where there is a videotape that would answer this question definitively that hasn't been produced here.
Thank you again. Yes, I made mention of that not only to the hearing officer, but I also complained of that in the review hearing documents, as well as before the district court on appeal.
What do you mean that you made mention of this? Was there a specific request for a specific sanction in terms of evidence and such?
I asked that the testimony of Mr. Ebling and Ms. Steger as to those topics of phone records, lack of surveillance footage be striked. I said that we're crippled. This crippled us from not being able to support or contradict the testimony of their 2 witnesses. And I stomped my feet about this a lot. Everywhere
you may have stomped your feet, but is there on the record before us an documentation of a specific request for a sanction?
I don't remember if I used the word sanction or not, but I did talk about the hearing officer's ability to. He said he would weigh the evidence as he saw fit. I think that was his response, if I remember correctly, because I objected to a lot of things. I am on the record in the transcripts of objecting to many, many things. And we were successful in impeaching the witnesses, but I guess if we could have won, I believe, exonerating my client if we had only been able to succeed on, but maybe that's going afield from what you asked.
Okay, just a larger question. What makes this a spoliation case as opposed to an ordinary case on discovery requests?
Well, this is a Rule 37 case. It's an issue regarding not only Rule 34 but 37, because the client as well as the employer should have had access to all the files, which they claim they did, to the footage, which they certainly accessed, and they didn't do any of it. I've got.
Can I ask Judge Milkey's question a different way? There's no
Please.
evidence that anything was destroyed, was there? There's evidence it wasn't produced, but there's no evidence anything was destroyed.
Well, I don't know if it was destroyed. There was no evidence but it was not negligent. Well, I would argue that it was negligently not kept and made available. If you can produce one thing and something else is very similar in time frame, like footage of surveillance cameras, and all of a sudden time has lapsed through this hearing and we don't know if we can get it anymore, I would call that negligence. And that's what the statute and the case law that I cited in my brief talks about. It talks about not only intentional destruction, but also negligent lack of preservation.
And can I have one more question? I'm looking at the hearing examiner's findings. There's actually a paragraph. I mean, you say that there's something about that he said about it speaks volumes. And there's something that says it's strange that the client who purported theft was not particularly helpful in producing the evidence. And he sort of used that as an adverse inference and found that the employer was okay with your client ordering the pool anchors. I mean, so actually, didn't they actually give you some benefit from the discovery violation?
Well, there was no testimony that that there was any implicit permission by the client for Mr. COTRONA to order and or use things. That was his inference, but there was no testimony that would imply a close friendship or collusion between Mr. COTRONA and other members of the client staff or management. He tried to understand how could this have happened, because you would think, obviously, a reasonable person would think the employer would be able to access the client, and the client would be supportive of anything that involved theft.
Right, and I'm saying is that it seems to me that the hearing examiner actually sort of gave a little bit of nudge in your favor based on the lack of cooperation. That's all.
I would agree that it was a nudge in our favor, but a better nudge would have been a sanction or making more of taking a much stronger position with the lack of evidence I had to exonerate my client by way of phone records, surveillance footage. I mean, they made a claim that they saw him walk out of the building to his truck with a box of pool anchors. This is a surveillance door footage, easy to get. And the phone records as to the ordering and the email history, it was their company laptop, company phone. They have all the records. I asked for them in the second subpoena. I got nothing.
Counsel, I should remember this, but it's been a long morning already. Did your client testify before the board?
Yes, he did.
So he denied the
Yes.
activities.
Yes.
So just to be precise, he didn't have an opportunity to rebut the allegations. He just didn't have the opportunity to produce corroborating evidence that you think would have, in your words, exonerated him.
Exactly, Your Honor.
Okay. Do either of my colleagues have any follow-up questions? Seeing none, thank you very much. We will now hear from Attorney Golke.
Thank you, Your Honors. Thank you, Your Honors. May it please the court. Grace Golke, appearing on behalf of the Department of Unemployment Assistance. Your Honors, I'll start with the spoliation argument, since that has been the crux of the questioning here and the crux of the brief. As Your Honors recognize, there was no spoliation argument ever made prior to this point. Spoliation being the destruction or loss of evidence that a party had a duty to preserve. There has never been any allegation or any evidence that such destruction occurred. But construing the argument more generously as an argument about improper withholding of evidence, that argument is still waived. So in front of the agency, in front of the review examiner, I wasn't handling the case at that point, but as I read the transcript, Mr. Joubert was arguing that the lack of evidence meant the employer could not show that this statutory bar to benefits applied. That's not the same as arguing that there was some impropriety on the part of the employer in being unable to produce these records. In fact, all the evidence in the record shows that the employer was not in possession of these records and could not possibly have produced them. I want to talk about the video evidence specifically because I think there are some factual misunderstandings from what is in the record, from what I've been able to review. And as I said, I wasn't handling this in front of the agency, so I'm relying on the same record that your honors are. And based on that record, what it shows is that Ms. Steger got this footage directly from the client. This is on.
Can I interrupt for a second? We have lost the telephone feed. I am assuming that Attorney Joubert can still hear us. But I would ask the clerk if she can separately confirm that, just so that we don't do anything improper here. If we can just pause for 60 seconds to do that. I apologize for the interruption. I will ensure you don't lose the time.
Not a problem.
And if Attorney Joubert could, if you could put a reaction, we probably can't see it, but anything from there to let us know you can hear us.
I've sent him a private message to see if he can hear.
Okay.
Because I know that when he logged in on his computer, I think he deactivated the audio.
So he should look at the chats at
Yes.
the bottom of the screen.
If he can hear.
If we cannot solve this problem, or at least confirm his being able to hear this, I think I am going to just go forward with the argument since he has no opportunity to rebuttal and will be able to access this argument from the YouTube archives, however that works.
Certainly.
I know it works because I've done it, but
right.
So I have not received a response, but he just joined the waiting room again. So I'm going to now.
Yes, here he is.
Would you also
I'm
mute
sorry.
him too?
I'm sorry. Yeah.
I was just noting there was a fair amount of background noise, I think, from him before. So
Yeah. Attorney Joubert, can you confirm that you can hear us?
Yes, I can hear. I'm sorry again.
Okay, no problem. And we will resume then with the ongoing argument. And again, I will give you a couple more minutes if you need to.
Thank
No,
you.
I'm good. Thank you much. Oh,
Attorney
Not you,
Gold.
the AHE.
Thank you, Your Honor. So I was discussing the piece of video surveillance that was before the hearing officer in this case. The record reflects, and this is on Record Appendix Volume 2 at 21 and 22. I believe it's discussed elsewhere as well, but that's one site, that Ms. Steger testified that she had received that directly from the client. I don't know where my brother has read or heard that Mr. Raymond was involved in getting that video surveillance. I did not see that anywhere in this record, and there isn't a citation to it in my brother's brief where that's stated. So to my knowledge, based on the record that I've looked at, it was the client directly, the client security team that is in control of these video surveillance cameras and footage that supplied that footage.
Counsel, just, I don't want to get too mired in this, but in any event, we don't know if Mr. Raymond is the one who obtained it. We have no idea how he obtained it. So as my law clerk can confirm, the best way to get research done is to ask someone else to do it.
Yes, Your Honor, exactly. There's no evidence that he independently had access or anyone else at ABM independently had access to these systems. In addition, the footage that was being discussed was not from the same day as the allegation regarding the pool anchors. The video footage that was provided was from October 18th. The allegation regarding the pool anchors was from October 8th, 2019. So these were two separate dates. They were not, in fact, on the same day. In any case, the larger point is that these materials that were subpoenaed, Ms. Steger, on the very first day of testimony, which was in February, testified that she had asked for these materials. They had not been provided to her. She said she would make a good faith effort to receive them, but it was clear to counsel from the first day of hearing that these materials were in another party's control. These hearings.
Counsel, if I can break in, you heard your brother say that whether it be on the record or not, he was told by the hearing officer that there was no mechanism for, if you will, subpoenaing the third-party records in. To your knowledge, is there anything in the record that establishes what the hearing officer may or may not have said?
No, Your Honor. There's nothing in the written record in any of the transcripts in which the review examiner or hearing officer, those terms are used interchangeably. There's no statement on the record about what steps can be taken to enforce an administrative subpoena that I have seen in my review of the transcripts. And I would point the court to Chapter 30, Section 12(5), which discusses how parties to adjudicatory proceedings like this one can enforce subpoenas in superior court. So that's a statute. That ability is out there. I don't know if something was said off the record by the review examiner, but I didn't see anything on the record, and that capacity does exist for parties in adjudicatory proceedings. In addition, a subpoena could have been sent directly to Charles River Labs, as was discussed. There were several months between the first and last hearing date in this case. There were actually 5 hearing dates. One didn't go forward because a party wasn't present. So there were 4 substantive hearing dates ranging from February through May. So there were several months in between that first hearing date when Ms. Steger first testified that she did not have possession of these materials and the final hearing date. So there was plenty of time in there to pursue these alternate avenues. So the combination of that failure to enforce the subpoenas, whether issuing a new one to the appropriate party or seeking enforcement of the existing subpoenas, as well as a failure to ask for any kind of sanction in front of the review examiner in the first instance, there was just never any suggestion that there had been impropriety by any party. In fact, counsel repeatedly made comments to Ms. Steger along the lines of, I believe that you've made your best efforts, or you can't control what you can't control. There are comments like that throughout. There's never any suggestion that there was improper withholding or destruction of evidence. And so what the board did instead was it relied on the evidence in the record. This was 10.5 hours of testimony over 4 days. There were multiple witnesses. There was a lot of documentary evidence produced. And so looking at this entire factual record, the board concluded that Mr. COTRONA had indeed engaged in an act of theft and that disqualified him from unemployment benefits. And there's ample evidence in the record to support that. I think the most telling, and frankly would have been enough by itself, are a series of emails that come from Mr. COTRONA's work address, are sent to a sales representative at an outside company, making the request specifically for these pool anchors. And in the first email—
Counsel, we are familiar with the facts. Tell me, what is your best theory as to how the hearing officer came to the conclusion that the acquisition of these was somehow approved by the company?
Your Honor, I want to be careful to say that it is a theory. So this is not in the opinion of the review examiner. There's no explanation really for why the review examiner came to that decision, and the board correctly concluded that there was no evidence for that. There was some testimony about a friendship between Mr. COTRONA and essentially the person who used to be his superior when he was working directly for Charles River Labs. He actually disclaimed that friendship himself in his own testimony, but that's my best guess about where this was coming from.
What do you think? What do you think of Judge Massing's theory that the speaks volume comment might somehow be related to this?
Your Honor, I would be speculating.
As was he.
Yeah, I think even if we were to read the opinion that way, that this was some sort of implicit sanction, it would not have been an appropriate sanction because, as I said, there's actually no evidence that there was improper withholding of evidence. And so the board correctly looked at this very voluminous record, concluded there was absolutely no factual finding by the review examiner or otherwise evidence in the record to support this theory that the client had somehow approved of theft from itself. And I think it's self-evident why that, without any proof, that would be a very odd thing to find. And I think the review examiner himself even wrote that it would have been dubious and inappropriate for that to happen. So it's very strange to have made this finding with no evidence while recognizing it would be a very odd situation to occur. And so I think the board correctly, it did adopt a lot of the review examiner's findings, particularly that Mr. COTRONA had made this order and that these emails were coming from him. They were sent over several days. And so the board did adopt those findings that were supported by the record, but on this particular last.
Just to clarify, isn't it fair to say that the defense here was not, this was approved, but I didn't do it, someone else must have?
Correct, Your Honor. The Mr. COTRONA flatly said, I've never seen these emails, I didn't send them, I have no knowledge of this situation. The supposition was that someone had sort of impersonated him, and the review examiner rejected that, found it implausible and not credible. And so the natural conclusion that the board drew from these findings that it did find were supported was that this deliberate misconduct had occurred. And I think that's amply supported by the evidence that's in this, as I said, very voluminous factual record. So I think in conclusion, unless the court has any other questions, I will rest on my briefs as to the substantial evidence.
I just like to make a comment on that. On page 43 of the record appendix, I caught something that made my jaw drop, where the review examiner wrote, "It must be pointed out that the level of evidence in administrative hearings is not even on par with the preponderance of evidence standard, but instead substantial evidence. If you could possibly get the word out to DUA that their hearing examiners should be looking for preponderance of the evidence, that would be better."
Yes, Your Honor.
Yeah.
Happy to pass that along.
And perhaps provide advice on the subpoena process in Superior Court.
Yes, Your Honor. I also, having heard, I hadn't heard before that the review examiner had made those comments, so that also kind of raised an alarm for me as something to pass along and make sure that the correct information was known to the agency as well.
Okay, hearing no further questions from the panel, thank you both very much, and to report back when she has done so.
And while that's happening, I'm just going to grab a charger, but I'll be back.
Can you hear the chainsaw? No.
We are live and recording.
Thank you very much. We are back for the fifth case on the docket. That is 2021 P142, and the case is John Doe number 502216 versus the Registry Board. I would remind parties that the case is impounded, and please no reference to the fund. And with that, I will. I want to remind the parties that we have read the briefs. We're familiar with both the facts and the arguments. So I would urge you both to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Faulkner, I believe.
Yes. May it please the court, I believe that the first error that I would address with your honors is with regard to the letter from Dr. Kearns and the treatment that received by the hearing examiner. The Superior Court Judge Howe found that the hearing examiner did in fact consider the letter, and that's in the record at 667. However, in doing so, she gave it minimum weight. I would suggest that that's contrary to the record, specifically in the record at 587 to 588. The hearing examiner specifically found that Dr. Kearns' letter does not meet the criteria required to receive mitigating credit under this factor. And that's simply—
How is that statement different from giving it minimal weight?
She's finding that it doesn't meet the criteria under the factor, but it does meet the criteria under the factor, and that's the error. In other words, if she were to find that it's not strong enough evidence, that's one thing, but she finds that it doesn't meet the factor's criteria because it doesn't address things that she adds in as criteria to the factor. Specifically, she wants the doctor, who's simply a medical doctor, to somehow give some kind of opinion as to how that affects his degree of dangerousness or risk of sex offense. But this is simply his physician, and that's not the physician's role in this. The physician's role is to simply give the condition and meet the other requirements of this regulatory factor. And that's exactly what this letter does. And specifically, I assume that the hearing examiner had in mind that sometimes these kinds of letters address, and given the subject matter of the case, I apologize, but they address things like erectile dysfunction and things like that. But here we have the physical condition being the fact that he has difficulty walking and with balance. And certainly in a case where he's alleged to have, I shouldn't say alleged to, but that the underlying offense involves a physical sexual offense, we're not talking about a computer type offense, a physical sexual offense. The fact that somebody has difficulty with walking and balance, certainly it seems, I think, obvious that even if it had no effect on the risk of reoffense, and I'm not suggesting it does have no effect on that, it certainly affects the degree of dangerousness where somebody would have difficulty pursuing a victim, obviously if they have difficulty walking. So that's where
Attorney
I think—
Faulkner, I apologize for the interruption. It's one of the somewhat graceless things about this mechanism. But my read of Dr. Kearns' letter and of the judge's treatment of it was that Dr. Kearns, if memory serves, her letter said that the condition, that your client's condition had begun before the offense that triggered this status as an offender. Am I right to remember it that way?
So the date of offense was in, I think,
2013.
It was
is that right?
2013, and the letter, if I can just have a moment, I apologize.
No worries. I can't find it either.
It puts the symptoms starting around 2014.
Okay, so it was after. All right, then never mind.
And, even if regardless of the timing, I would suggest that even still, it's something that would have to be considered in terms of the degree of dangerousness. Because even if he had been physically able to even if he had been physically able to engage in one sexual offense on one occasion, the SORB is tasked with determining the overall degree of dangerousness, so that the fact that he's reduced in walking is just a factor that has to be considered as to how dangerous he is. He would certainly be more dangerous if he could, it was 20 years old and was a track star and could run. And I don't think the SORB can argue any differently than that. And so, again, what the hearing examiner had to do was consider that evidence and consider its impact on the case, not to simply say it doesn't meet the regulations and for that reason I give it minimal weight, when in fact it did meet the regulation. It did exactly what the regulation called for. The regulation didn't call for the additional information that the hearing examiner claimed that it needed to have. The second issue, I think, that's of particular importance.
Actually, before we get to the second issue, to what extent are you suggesting that the regulations required the hearing examiner to give it more than minimal weight?
I'm not suggesting that the hearing examiner was required to give it any particular amount of weight. My issue with the hearing examiner's treatment of that letter is not the weight that she gave to the letter in general. It's the fact that she wrote that it does not, the reason that she gave it minimal weight is because—
No, I understand what that piece of it, but if the hearing examiner could have granted it minimal weight anyway, for other reasons, how much is this a reversible error in a case that's had now several hearings in the same proceeding?
Well, I don't know that the prior errors in the proceeding that have caused additional hearings change what would be reversible or not reversible at this stage with regard to this particular hearing. I do realize that it has had several hearings, but if SORB is charged with getting these things right. So the fact that it has multiple hearings is in part based on the fact that SORB has not been able to get this right. With regard to the amount of credit, I don't think it's for this court to determine what weight she could have somehow still given it minimal weight. I don't think there's anything to indicate that she necessarily would have had she determined that it did comply with the regulation, which it did. Secondly, I think her treatment of it, the fact that she gave it minimal weight, still is an issue that is in and of itself a problem, because of the fact that, again, this SORB is required to prove the degree of dangerousness by clear and convincing evidence.
Counsel, I'm going to call a timeout. I derailed you from moving to your expert issue, fees issue, and I want to allow you to go there.
Yes.
So I withdraw the comment for now.
Understood, Your Honor. With regard to the expert, this is the problem with the setup where the Sex Offender Registry Board is determining who gets funds for an expert and who doesn't. It creates this catch-22, because without the funds, you can't hire the expert. The expert can't therefore provide the evidence that's necessary in order to support the request for funds. In this case, he actually did have an expert previously that opined that was willing to give an evaluation that complied with the requirements of what the Sex Offender Registry Board needs. And the reason that it was denied essentially is because the finding that the hearing examiner made was, well, the only thing that Dr. Winsman had to say was that he committed this offense because of alcohol. And that's not a fair reading of Dr. Winsman's report. Dr. Winsman's report finds that he committed this offense as a result, in part, of his insufficient degree of relationality, which also was a cause of his alcohol consumption, which in turn was a partial factor in support of it. So the fact that alcohol consumption was a factor in committing his offense, I think, is undisputed. But the mere fact that alcohol consumption was a factor in his committing the offense does not render Dr. Winsman's report meaningless. SORB just assumes that that's the only thing that the report goes to, and it's not the only thing that the report goes to. It certainly addresses alcohol use.
This? Judge House said he characterized the denial of the motion for funds as it was just asking for funds for Dr. What's his name, Winsman's opinion on the risk of reoffense. And the motion was not. You're characterizing it now as a specific motion for how the interplay between his mental illness and his alcohol abuse caused, circumstances that happened just once. But the judge read the motion as asking for something else. And how can you help me get to how the motion, which I think is at pages 461 to 463, is asking for something other than an opinion of Stone's likelihood of reoffense?
If I can just have one moment to pull that back up.
Sure.
and would
that was a pseudonym, by the way.
Excuse me?
That was a pseudonym. I absolutely never said a name, but that's a pseudonym. So.
Oh, yes. And could I have the page number again, Your Honor?
461, 462, 463.
I see.
Is that the motion that we're talking about?
I believe that is the correct motion that we're talking about. And I would simply point out with regard to that motion that the report itself was an attachment to that motion. Right. So that goes on page 464 and onward. Right. So again, the point of that motion was that Dr. Winsman had made an opinion. His opinion is set forth in his report, which is attached to the motion. So I think for those reasons, it is it appropriately encompasses his opinions that he had previously made, and that therefore that makes the showing that's necessary for the funds.
Attorney Faulkner, let me pause you there for just a moment. I want to make sure I understand sort of the record consequences of the denial of this motion for funds. So my understanding is that although Doe had been involved in substance abuse treatment and potentially also mental health counseling during the period that he was on probation, that there was not an update available on the record to the post-probation period of the time before the hearing began. Am I right about that?
That's correct. So Dr. Winsman's report takes place pre-sentencing in the Superior Court in the criminal case. He engages in mental health treatment. He engages in substance abuse treatment. He engages in probation. He completes all of that. And he's in a different place in his life, obviously, at the point when he's being classified by SORB. And so that's why an updated report is necessary and an updated evaluation, because these, as the SORB, as the case law demonstrates, the picture is what is somebody's risk of reoffense and degree of danger at the time of the classification hearing, not at the time that he's being sentenced in the criminal case.
And you mentioned the case law. I wanted to turn your attention to one of the cases that I thought was sort of important to keep in mind, at least for me in thinking this through, is Doe 234076, which is a 2020, I think, SJC decision about expert funds. And looking at that case, I was sort of struck by the language that appears on page 672 of that decision, which says the duties of the, and this is quoting the regs, the duties of the hearing examiner also shall include assisting all persons in making a full and free statement of the facts in order to bring out all the information necessary to decide the issues involved. In your view, how does that language, if it does, have anything to do with the availability of expert funds to Doe in this case?
So I see my time has expired, if I may answer the question.
You may answer.
So I think that language is exactly the problem with what happens in this case. So Mr. Doe needs to be able to present, wishes to be able to present evidence which would be of assistance to the hearing examiner in making the decision. That evidence is available, but if Mr. Doe had funds, he can pay Dr. Winsman, and Dr. Winsman can present that evidence, and that evidence is something that the hearing examiner is bound to consider if he had money. But simply because of the fact that he doesn't have the money to be able to retain Dr. Winsman, he needs to go back to SORB to get the funds. SORB says, no, you can't have the money because you didn't make a good enough showing to need the money. And by the way, the result of that is that we don't consider Dr. Winsman's opinion because you didn't put him on the witness stand. So it's exactly that. SORB denies him the ability to make the presentation, the full presentation of evidence to the hearing examiner that he needs to be able to do. And if there are no further questions, I'd rest on my brief.
Let me check with my colleagues. Hearing none, thank you very much. We'll hear from the board.
Yes, and morning, Your Honors. May it please the court.
Afternoon, but.
Oh, good afternoon. Good afternoon. I was so focused on the 11:30 start. Sorry about that. Good afternoon, Your Honors. May it please the court. John Borsay for the Sex Offender Registry Board. If I may, I'll just pick up where the good counselor from Andover left off regarding the denial of expert funds. And this is a case in which SORB does recognize that Doe has a history of mental health issues. However, we believe that there was strong evidence that alcohol caused Doe to sexually offend in June of 2013.
But,
during
counsel, that may be true, except as you know, alcohol abuse and mental illness can be comorbid or whatever the term is. And it's may not be unusual, but it is something that is specific to this person. Why shouldn't there be an exploration of the relationship between those here and the effect on reoffense, on the risk of reoffense?
Yeah, so sure, Your Honor, and you raise a great point, because I have seen that correlation in several SORB cases. However, I think this case is different because the Doe self-reported to Dr. Winsman that he became intoxicated on the day of the governing sex offense. He didn't tell Dr. Winsman that, he was having these negative emotions and that caused him to drink. So there was strong evidence that he was intoxicated on the day of the governing sex offense. And then he actually wrote letters to the SORB saying that he was intoxicated, and he knows that if he wasn't drinking, he wouldn't have committed the governing sex offense. Additionally, Dr. Winsman's report does, draw that correlation between Doe having the negative emotions and drinking, but there's also a lot of references in Dr. Winsman's report of that the ability of Doe to refrain from abusing substances and from drinking will lower his chance to sexually reoffend.
So
Attorney Borsay, am I,
Yeah.
oh, sorry, you still going? Justice
No, go
Milkey?
ahead.
Am I right to think that the most up-to-date information that was before the board about Doe's alcohol abuse and or sobriety, as the case may be, was many years old at the time of this hearing?
So there was a period before the governing sex offense where Doe was abusing alcohol, but then there was a period afterwards where he started to receive a lot of mental health treatment, and there was all indications that he wasn't abusing alcohol and drugs anymore. You know, he was doing well at some of the sober houses he was living. He was doing well on probation. So I apologize. Does that answer your question?
Well, it does kind of. I mean, I know that information was part of the record. I guess there's sort of two things I'm looking to fill in, or I'm looking to find out whether are filled in by the record, which are how close into, is there any gap in what is in the record, of a gap in time between the time of probation and the time of the hearing in what we know about whether Doe was sober or not, and also in what we know about whether he was receiving mental health treatment related to whatever triggers may have caused, according to Dr. Winsman, the alcohol abuse.
Oh, right. So my memory is that the most recent evidence is that after the governing sex offense in 2014, so between 2014 and 2017, there was no indication of substance abuse, and he was receiving the mental health treatment. And I apologize, but my memory is that we did have that gap between 2017 and 2019 of evidence of, you know, continued mental health treatment. And but in all fairness to Doe, we also we had a recent updated criminal record, and there was no indication of, you know, any additional criminal conduct like public order offenses, OUIs, things of that sort.
And if the money had been, if the money had been allowed for Dr. Winsman, based on his prior report, is it fair to think that the report from Dr. Winsman would have provided the board with an updated snapshot of Doe's intertwined mental health and substance abuse disorder situation? In other words, would have provided the board with an ability to assess Doe as he was at that moment, as opposed to a couple of years ago when probation ended?
I think, yes, I do think that's fair to say.
Counsel, to what extent is the board in effect arguing that given how its regulations are drafted, it matters whether Doe is engaged in alcohol abuse, not the reason for that, and therefore we don't really care about the potential mental health components of the alcoholism? There's a flavor of that here, and I'm trying to tease out what the board is really saying.
And Your Honor, if I understand your question, I think the SORB in this case, again, found that the correlation between the alcohol abuse caused the offending, and as a result, we have a regulatory factor that addresses that, and expert funds was not necessary. In other words, there wasn't a strong correlation between the offending and mental health.
No, but if and you didn't have this at least updated information that went to that issue. But, you know, assuming the good doctor could examine this issue and opine on the extent to which the alcohol abuse was tied up with the mental health and say that, the SORB has its regulations, but it ain't so simple. Here's why. Why wouldn't the board want to hear that?
Well, I certainly think that anytime you have an expert, it's a lot of times the expert can provide relevant information. So yes, I agree with you. I can't disagree with you that I don't think Dr. Wiseman could provide relevant testimony, but because the board does have the discretion, well, the offender has to meet his burden, and in this case, it's my position that the offender did not meet his burden because, again, there was strong evidence that alcohol abuse caused this governing sex offense.
To follow up on that, go ahead.
I'll let you follow up.
Well, then you can follow up again. I want to ask you to comment on the application of a particular case to Doe's claim here, which is Doe 151564. It's a Mass Appeals Court case from 2014. And in that case, the offender was an older man. I think he was in his early 60s by the time the case and the classification issue came about. And the request for expert funds had been denied, similar to the case here, on the principle that age is one of the enumerated factors. So we're not going to give you money for somebody to talk about age. And the appeals court decision says, in essence, and I may get this wrong, that the importance of an expert in this context is to talk about how the age-related factor relates to this particular individual, and especially someone who was already of relatively advanced age at the time of his offense, as the person in that case was. Why doesn't that case apply here to say, yes, alcohol abuse is a factor, but we don't know how that factor applies particularly to this Doe, and expert money would assist the decision maker in figuring that out?
Yeah, and Your Honor, so my memory of that case, that was in 2014 before the board updated its most recent regulations in 2016. And in that 2014 case, the board did not have a regulatory factor that addressed advanced age. So because we didn't have a regulatory factor that addressed age, this court held that SORB should have allowed expert funds to address age. In this case, because it's our position that there was a correlation between offending and drinking, there is already a regulatory factor that addresses substance abuse, and that's why I cite in my brief to the 2020 Supreme Judicial Court case that said that hearing examiners do have the discretion to deny expert funds on regulatory factors that the SORB's regulations are already addressed.
Okay, that's helpful. So it's your position, I trust, but tell me if I'm wrong, that if the age case, 151564, had come up after that change to the regs, that the outcome should have been different.
Correct, and I believe that there's been a number of unpublished cases from this court where they have said that the hearing examiner properly denied motions for expert funds regarding age because we now have a regulation that addresses age.
Can I ask one? I noticed that this is a fairly old decision. It's from May of 19, so it was prior to 496-501 that required the specific findings on the three factors, including the public safety interest from internet publication. So there's no specific finding on that here. But actually, this is answer me this. Do you have to find all three of those? That there's moderate risk of offense, moderate dangerousness, and public safety interest in internet publication to classify somebody as a level 2? Or is there such thing as a level 2 who doesn't have to be on the internet?
Right. So for all level 2s after July 12th of 2013, they're required to, their information is required to be on the internet, and under that new SJC case 496501 from 2019, hearing examiner has to make specific, explicit findings for each element, and each element has to be shown by clear and convincing evidence.
So if you don't find the third one, then he'd have to be a level 1.
That's correct, under the decisional law, yes.
Okay.
But that's going forward unless we exercise our discretion to send it back on that issue where the
Right,
issue has
but
been raised.
In this case, I believe that the issue was waived because I would have wrote about it.
Yeah, no, it's not raised.
My-
It's not raised. It's
Okay. All right.
Any updates to the SOAR regulations coming?
I know that they are working on them thoroughly, Your Honor.
it's kind of a compulsive question, Justice Milkey.
Your Honors, I know you've already had a long morning and now into the afternoon, so I'd be happy to address the issue about factor 31, the physical condition, or I can rest on my.
You have 31 seconds, so however you want to use that time.
I was gonna, I'll just say that the hearing examiner did consider it, and at the end of the day, her job is to consider risks to reoffend and degree of dangerousness, and that there was no information in that letter that spoke about as a result of these medical conditions, the offender has decreased libido or sexual dysfunction. So I can leave it at that.
Okay, thank you both very much.
Okay, we are live and recording.
Thank you very much. We are back online for our 6th out of 7 cases. This case is Lamport v. Draper Place and another 2021 P622. I would remind the parties that we have read the briefs and the record, so we are familiar with the facts and the arguments. So to the extent possible, I would urge you both to cut to the chase. And with that, I will turn the floor over to Attorney Sheehan.
Good afternoon, Your Honors. May it please the court, John Sheehan for appellant Mary Lamport. The administrative judge's hearing decision, I would respectfully submit ordering post lump sum medical benefits under the workers' comp statute was not arbitrary, capricious, contrary to law, or beyond the scope of her authority. And as I outlined in the brief, the facts and the issue presented in this case is remarkably similar to an unpublished case from the appeals court, Daniel Wilson's case, 2016 case.
Well, it's published. Wilson is published.
I stand corrected.
Yeah, but the problem, I like you addressed, the appellee's main contention is they say that Wilson hasn't. I mean, it's factually similar to this case, but in Wilson, the insurer had waived the claim that the lump sum payment bars recovery. So there was no. So when we reversed, it was on the issue of causation and not on the issue of what was the effect of the lump sum payment. So could you please address the fact that there was a lump sum payment for the right shoulder? Why does that not preclude injuries from the same accident on the left shoulder?
Because the administrative judge at hearing, she had evidence before her that she explained in her hearing decision. Number one, the credible testimony of the employee that due to the delay in getting surgery for the right shoulder that was approved, It was about 10 months. And then post-op, she had to have her right arm immobilized for, I think, a couple months, 8 weeks. And with her treating physician, the judge had medical evidence at hearing for this claim post-settlement, Dr. Kasparian, that there was a causal connection in the rotator cuff injury to the left shoulder.
Nobody's contesting the causal connection. She was aware of the left shoulder pain before the lump sum payment agreement, right? Which was in 2018.
The liability was accepted for the neck and the right shoulder. They were addressing possible left shoulder, or they weren't sure if it was cervical, if it was neck, at the time that she was receiving treatment before the case settled.
Counsel, why now? We're starting to get to the heart of it, because I mean, why isn't the issue just a question of the scope of the settlement and the scope of the release of claims? And tell me if I'm wrong, but as best I understand it, the only place in the record that is actually addressed is on Record Appendix 244, which is the form in which the agreement for redeeming liability by lump sum payment was executed. And toward the middle of that page, there's the language about the parties understand and agree that the herein proposed lump sum settlement closes out any claim that the employee may have. And then it goes on with additional language. I mean, am I missing something, or doesn't the case just turn on the meaning of that language?
The section of that was page 2 of the approved workers' comp lump sum settlement agreement. It said the parties understand and agree that it closes out any future indemnity, which are lost wage benefits, including 28 and section 36. 36 is loss of function. The liability was accepted and not closed out for the future medical treatments for the accepted injury. Now, I understand the accepted injury is listed in the approved lump sum is for the right shoulder and the neck. My position is, and the administrative judge, the hearing judge, found that the left shoulder is implicated because of the accepted.
No, but I'm not. Yeah, I'm not even going there. I'm just talking about what's the legal framework in which we're resolving this. People enter settlements all the time, and issues arise about what was the scope of the settlement and what claims were released. Am I correct that this is the language, or is there something else here? Or is it something that's as matter of law? What's the governing principle here in terms of what was settled?
It's my view, Your Honor, that the governing principle is that the employee's right to post-settlement medical benefits for the diagnoses and injuries accepted in the settlement are not settled, that she maintains her rights.
But what are you pointing to? What is it, this language? Is it some other language? Obviously, she settled something.
Oh, yes, obviously. She settled the workers' comp case, and in the top portion of that, on page 244, diagnoses: right shoulder rotator cuff tear, status post right shoulder arthroscopy, cervical sprain strain, exacerbation of pre-existing cervical degenerative disc disease. So by the case settling with liability accepted, the employee's rights to medical benefits under sections 13 and 30 of chapter 152, the workers' comp statute, do not settle. Because of that, and Dr. Kasparian's findings that the later discovered rotator cuff tear on the opposite shoulder, the left shoulder, was caused by the accepted right shoulder injury and the employees having to overuse the left shoulder and the left upper extremity. That's the basis, in fact and law, that we asked the administrative judge to order the medical benefits for the left shoulder, and that was the basis of her decision.
No, but am I correct that it's this paragraph on page 244 that governs this case? Or is there something else?
Well, it's the whole, if on page 243, Your Honor, you'll see at the, in the middle section, it says check where applicable. Is the, that's the workers' comp settlement agreement. So you'll see that the top section is, there's an X there. Liability has been established by acceptance or by standing decision of the board, the reviewing board, or court of the Commonwealth, and this settlement shall not redeem liability for the payment of medical benefits and vocational benefits with respect to such injury. Then on page 2 of this, which is 244 of the appendix, it spells out then in the section I was just referring to, next to the diagnoses, what was accepted. So those listed diagnoses did not settle. They remain open as a result of the workers' comp settlement.
So the examiner held that, yeah, it only says their right shoulder doesn't cover the left shoulder, so that we must have left the left shoulder open. She was reversed because the board said, no, our rule is that you have to carve out specific things that you want to keep open, and it wasn't carved out. And they rely on a bunch of their workers' comp decisions. Are those wrong?
I would say they're right if, for example, there was a claim made for medical treatment that had absolutely nothing to do with the accepted injury. If all of a sudden, for example, hypothetically, she said that she had a sprained ankle, something completely disconnected from the right shoulder. But in the facts of this case, in the evidence that the hearing judge found, there was evidence that she had this condition that was discovered by MRI post-settlement related to the accepted injury. Because of the injury to her right shoulder, she was overusing her left arm and left upper extremity for a period of 10 months, actually a year. And because of that, it was her treating doctor's opinion, Dr. Kasparian, which was evidence at hearing that the left shoulder rotator cuff tear was caused by the overuse due to the accepted
Counsel,
to the right shoulder.
I think we understand the argument, but I want to go a step behind Judge Massing's excellent question, and that is, what role does the agency have in pronouncing what its settlements mean? We have a document here. This is the document that the parties use to settle their dispute. How does the agency get to opine on the scope of that? Isn't it a question of contract in terms of what the parties agreed would be released?
Generally speaking, yes. But again, what was not released were the right to file a claim for future medical benefits in the event that there's a dispute post-lump sum between the injured worker and the insurance company, which was.
But what legal framework do you think applies? Not what specific argument are you making within that framework? Do you accept the agency's apparent position that it gets to say what gets resolved when people use its forms? Or is this more of a legal question that courts should be looking at based on the language of whatever agreement the parties signed?
Well, the settlement agreement in the form published by the Department of Industrial Accidents sets forth, again, the agreement, and I accept that. But because of the underlying facts in this case, and for the reasons that the administrative judge issued in her decision, which I believe were correct, both factual, evidentially, and supported by the law as far as the medical benefits not being redeemed, not being closed out. I think that this is unique to a situation like this, where you have an underlying undiagnosed injury, but it's caused by the accepted injury that no one disputes. The right shoulder was accepted. And I think it's a pretty straightforward fact pattern, and the administrative judge, who's in the best position as the trier of fact, heard testimony that she credited to the employee. And,
yeah, no, but isn't the question, what is it that the parties agreed to when they signed this lump sum agreement? Because they could have reserved this, they may have reserved it, but the question is, did they? Not the relationship between these injuries.
Well, as far as that goes, on the four corners of the approved settlement, pages 243 and 244 of the appendix, it's silent as far as that, whether it was reserved or precluded. But
and I think, I think that's the question that we've been trying to get at, Attorney Sheehan. My understanding from reading the cases is that if it's silent, you lose. In other words, any injury that is covered by a settlement needs to be explicitly set out or explicitly reserved. And there's no reservation in this document of the left shoulder injury, which was known to the parties at the time.
She had had the shoulder looked at, but again, she did not have an MRI of the shoulder at the time. There was no finding of a tear. And in fact, there was questioning by her treating doctors whether it was cervical or whether it was the shoulder, as far as the reason for the symptoms that she was presenting with. I would just further, Your Honors, rely on the brief that we submitted, and I thank you for your time and attention.
Thank you. Let me just check with my colleagues to see if they have any further questions. Seeing none, thank you very much, counsel. We will hear from Attorney Martin.
Thank you, Your Honors. May it please the court, Attorney Robert Martin for the appellee, Safety National, the workers' comp insurer for the employer in this case. Justice Milkey, you asked a very pointed question in your presentation of whether you were missing anything in this case or on the issue of this case. And let me provide a very pointed answer to you. No, you are not missing anything. This is a simple case with a simple legal issue, which the reviewing board got right. And that is that the parties here agreed to a settlement with certain terms, certain defined terms in the settlement, most notably the limited medical diagnosis, which is the issue at the heart of this subsequent claim. In that limited medical diagnosis governs the parties' rights for future medical care for the accepted injury. The employee, through this claim and now through this appeal, is trying to fundamentally alter that settlement agreement and expand its terms beyond what was agreed to by the parties.
Okay, but the issue is what was agreed to by the parties. And speaking only for myself, at least on a first read, I'm finding this agreement less than clear in terms of spelling. I mean, all the release language that I'm familiar with in past lives is a lot more explicit in terms of what is in, what is out. And here, both sides seem to be asking us to read a bunch of stuff into it. And the agency appears to be asserting its own role and saying, well, this is how we do things. And if you don't like that, brush up on your bevy of administrative cases before us. What can you, pointing to the language of this agreement, help me go through it in terms of what was released.
Yes, Your Honor. Let me clarify. I'm not asking you to read into anything in the settlement agreement that's not there. It's crystal clear what is accepted under this lump sum, both in the narrative, which you pointed to the language that it release any and all claims other than those that are of the above diagnoses. That part of a standard lump sum settlement, which is on page 244 of the record appendix, which lists diagnosis at the top portion of the page. That section is where the parties lay out what diagnoses are being accepted, what body parts are being accepted on any lump sum settlement, not just this case, but in any. And that one is crystal clear about what is accepted. It's right shoulder rotator cuff tear, status post right shoulder arthroscopy, a cervical sprain, strain, and exacerbation of pre-existing cervical degenerative disc disease. There is nothing in that written accepted diagnosis about the left shoulder. There's also nothing in the narrative about the left shoulder.
But don't you see why that's a problem? Because if it doesn't say anything about the left shoulder, you could read it as saying, well, it leaves open anything about the left shoulder. How does it close out the left shoulder?
Respectfully, Your Honor, you wouldn't, it doesn't read that way. If you brought that position to its logical conclusion, every lump sum settlement would have to, and I included this in my reviewing board brief, but not in the appeals court brief, as a footnote to illustrate the absurdity of that line of thinking. If that was the case, you would have to list on every lump sum, this settlement does not include, as an accepted body part, the head, the neck, the other shoulder, the other arm, the other elbows, the other wrists, the other hands, etc., all the way through the body. That's absurd.
But is the general release language what I pointed to at the beginning, the last sentence of that middle paragraph?
The parties understand and agree that the herein proposed lump sum, is that the sentence you're referring to? Yes, it closes out any claim that the employee may have other than that which is listed in the settlement agreement. The four corners of the document discuss only the acceptance of a right shoulder and a cervical condition, nothing about the left shoulder.
So are there any decisions other than, DIA decisions that state the rule that the lump sum, it bars different injuries unless they're specifically set forth?
Yes, Your Honor, there's, well, as you stated, there's plenty of reviewing board decisions, but most of them don't get up to the appeals court. There is one in particular, LaRoche's case, which is 84 Mass App Court 1132 is the citation. It's a 2014 claim. It was a Rule 128 decision. Well, now it would be a Rule 23, but back then it was a Rule 128 decision, which affirmed the reviewing board's denial of a back claim after the settlement of a lump sum for a knee injury. If you took a look at the reviewing board's decision in that case, which was affirmed by the appeals court, the employee tried a claim for a knee injury. It was granted. The parties then settled for the knee. And then later on, the employee brought a claim for a back injury with the same date of injury. And the board said, no, it's precluded by the prior lump sum. That's an approved settlement. It's analogous to a final judgment on the merits. Res judicata applies that claim for the back injury should have been brought at the earlier litigation. And that's what was affirmed by LaRoche's case at the appeals court. It's a very brief decision by the appeals court, but it is affirming the reviewing boards.
And it's unpublished.
It's a Rule 128, yes, Judge.
Attorney Sheehan pointed to page 243 of the appendix and the checkoff that says liability has been established by acceptance or standard decision. And then this language, this settlement shall not redeem liability for the payment of medical benefits and vocational rehabilitation benefits with respect to such injury. What does that mean?
Well, that, Your Honor, with respect to such injury, that language is limiting that it's not redeeming liability for medical benefits to such injury. That refers to the accepted injury on the lump sum. In workers' comp cases, medical in Massachusetts on an accepted liability case remains open for the rest of the employee's life for the accepted diagnosis.
So that's the importance of putting down the right shoulder stuff. So right. There's some sort of future compensation for that.
Right. You cannot close out medical benefits in Massachusetts unless it's an unaccepted liability case, which we'd be getting into the weeds there. On accepted liability cases, you cannot close out medical in Massachusetts. So that's why that language is in there.
Okay. The sentence that I began by reading, or at least starting to read, references sections 28 and 36. What are those sections about? I should know the answer to that, but I don't.
Section 28 is the employer's serious and willful misconduct. It refers to if there's some sort of quasi-criminal conduct that caused the injury, the employee has a right of claim against the employer for double compensation. Very rarely it comes up, but in those cases.
But if those sections are so limited, then this language doesn't generally release, doesn't say it closes out all claims they could have brought under the applicable substantive permanent injury kind of sections.
It does, because the 28 claim is against the employer. So it's specifying that the 28 claim is also contemplated by this agreement.
No, I understand this language adds, or at least makes clear, that section 28 and 36 are covered by this settlement, lest there be any doubt about that. But on its face, this language doesn't appear to be a general release, or if you will, closing out provision with regard to the ordinary sections that whose numbers escape me.
13 and 30.
So where is the language that states what the legal import of this lump sum settlement is? Or is that something that is just either implicit in the nature of a lump sum settlement or subject to interpretation by the board or department, whatever it's now called, or something along what Judge Hershfang was saying in terms of resolved by presumptions about effects of settlements in the context of silence?
It is inherent in the lump sum settlement, Judge, that the listed accepted diagnosis is what is the limiting language for future medical claims, and that's the listed diagnosis is explicit there, right shoulder and neck. What Justice Hershfang said was, she asked whether it's correct under the prior cases that if a settlement is silent as to an issue, you lose that issue, and that is a correct interpretation of the cited case law in my brief and in Attorney Sheehan's brief.
But by cited case law, do you mean in the DIA administrative cases or reported appellate cases?
Both. There's cases that there's plenty of reviewing board cases. There's also cases on separate sort of issues about the limiting aspect of a lump sum settlement at the appeals court. Hanson's case, which is a 1966 case, 350 Mass 178. Once a lump sum settlement is approved, further inquiry into the merits of the original controversy is precluded unless the agreement is set aside by the Superior Court. That's speaking to rescission of the agreement by the Superior Court, which was not sought in this case. There's also the cases on, the doctrine of mutual mistake, which is LaFleur, which 398 Mass 254. That outlines how the lump sum settlement can be revisited in the very limited case of a mutual mistake as to an unknown injury, which does not apply in this case. Obviously, the alleged left shoulder stuff was known prior to the lump sum. Mueller's case is a Section 36 case that bars the Section 36 claim is barred by the approved lump sum.
What's Section 36? What's Section 36? That was the other one that's mentioned here.
Permanent loss of function.
So you were saying something about the difference between established liability and what were the two things there?
Well, you could have an accepted liability case or a without liability case. That's, if for some reason the parties disagree whether an injury ever occurred, you can settle it without liability.
Okay, so this was an accepted, was
Yes.
this an accepted liability case?
This is an accepted liability case with regard to left shoulder and cervical, yes, or right shoulder.
Right shoulder.
And that's the significance of the check off at the first box there.
Yes. Your Honor.
I noticed there's one. I mean, there's a. We haven't talked about it yet. Section 48 is called lump sum payments.
Yes.
And there's a section in there that says no lump sum agreement made prior to the establishment of liability for compensation shall prohibit certain claims. Is this a lump sum agreement made prior to the establishment of liability?
No, liability was already established in this case.
Okay.
By way of an earlier employee's claim, which a conference order ordered benefits. This is years and years ago, we appealed and withdrew our appeal of the earlier conference order that established liability for the right shoulder and cervical. And once that was established, we settled the case, obviously, by way of the lump sum. So that particular portion of Section 48 only applies to settlements prior to the established liability.
So, counsel, we understand your arguments. Would you perhaps acknowledge, though, that this form could perhaps be clearer so that the employee knows what she is giving up or not giving up?
Respectfully, Your Honor, I would not concede that point. This settlement in the general practice of the DIA is crystal clear as to what is accepted. And I'm surprised that this claim was sought. And again, I would refer to you to the absurd conclusion of that reasoning as to you would have to list every single body part in the human body.
No, I respectfully disagree. You could easily draft a sentence that made it clear what, the scope of claims without reference to body parts that were being given up.
Yeah,
but that is
a general release the way.
But that is what the narrative refers to. The narrative talks about all of the treatment of right shoulder and neck. It does not talk about left shoulder. And frankly, it's not the insurer's, place to add in a body part. It should have.
No, I wasn't suggesting.
It should have been reserved. It wasn't.
Yeah, what I'm trying to say is that there appears to be a lot of inside baseball in terms of what people's understandings of these settlement agreements mean, and they seem to be to a great extent untethered to the actual language of the DIA form.
No, I've got a question.
Sure.
That if in that diagnosis it had said left shoulder, would then notwithstanding this lump sum payment, would the employee be able to get the medical benefits, the arthroscopic surgery or whatever for the left shoulder?
Yes, if left shoulder was listed as an accepted diagnosis, she could bring a later claim for left shoulder treatment. It would be subject to the usual review of whether it's reasonable, adequate, and causally related, but it would be a claim that could be sought.
So lump sum payment doesn't really mean this is the last penny you're ever going to see.
It does for weekly indemnity benefits.
Okay.
It's just
but not for medical.
And vocational rehab services are also remain open for 2 years. But I see that my time is up. Thank you.
Do either of my colleagues have any follow-up questions? Seeing none, thank you both very much.
Okay, we are live and recording.
Thank you very much. We are back live on our 7th case of the day, Commonwealth versus MCILROY, 2020 P 1174. I do want to remind the parties that we have read the briefs and are familiar with the arguments, and therefore I would urge both of you to cut to the chase to the extent possible. And with that, I will turn the floor over to Attorney Pedani.
Thank you, Your Honor. Thank you, panel members. Good afternoon. Sina Pedani for Mr. MCILROY. Your Honor, I intended to start with the manifest necessity argument, unless the court has a preference I do think that's an appropriate place to start. The court, as is certainly aware from reviewing the briefs, declared a mistrial in this case after some arguably improper testimony from Officer Nevin. Officer Nevin testified that when asked whether he formed an opinion at that point, the officer responded that he did form the opinion that the defendant was operating under the influence of alcohol. At that point, he placed him under arrest. Now, defense counsel did not object to this at the time, and that was a strategic decision, as we would later learn in the arguments that were held outside of the jury's presence. And the judge was cautious to not call a recess right at that moment. So I don't think any attention was drawn to that particular testimony. And after the recess was started, they essentially put their concerns on the record. The judge made very clear what her concerns were. But on that point, I believe that one of the considerations for this court is the judge's understanding of the degree of taint, so to speak. The improper testimony, while coming close to the ultimate issue, is not, in fact, what the holding in Canty prohibits. The crucial point in Canty was not that the defendant was operating under the influence of alcohol. It was that last link of...
Counsel, let me just break in, and speaking only for myself for the moment. I think there's a fairly clear Canty issue here. You raised a good retort, putting your ADA hat on, saying that there would not have had the case gone forward, it's not likely that we would have found reversible error. The issue was raised by the judge. Trial counsel was, very candid in saying this was strategic. I would rather not highlight the issue. So I don't want the evidence stricken. I don't want a limiting instruction. So as between going forward with the potential Canty problem or doing these curative things, I prefer going forward. So that's all clear. The prosecutor raises the possibility of a mistrial. The judge is looking at this, is torn about what to do. The choices she presumably faced are giving a curative instruction and or striking the evidence over counsel's objection, going forward with this without any such remedial actions forward, or calling a mistrial. And looking at those options, needless to say, it may not have been the smartest thing to do to give the instructions and strike the evidence over the objection of counsel, so that if you bear with me so far, the choices are declaring a mistrial or going forward with this problem. Had she gone forward with this problem, what happens? Either we reverse and send it back for a new trial, or we affirm, in which case your client is convicted anyway. So before we get too tied down in doctrine, what's the real problem here?
Well, I think Your Honor has perfectly highlighted the real problem. I think that question, it would have been extremely prudent to pose that question to Mr. McIlroy. Once defense counsel unequivocally expressed his desire not to draw more attention to this, explain the strategic decision that he had made, the thing to do would say, well, this is where I'm at. I believe that a mistrial is manifestly necessary. So would you like the instruction or a mistrial? I think that would have obviated much of this. But then also, Your Honor, I think that the prospect of an appeal, as we know, the decisional law in this Commonwealth is very clear that the prospect of an appeal is never sufficient to create manifest necessity to declare a mistrial. That was stated in Commonwealth versus Donovan and Commonwealth versus Elder. Elder is cited in my brief. I believe Donovan is as well. And so when we are looking and evaluating at that juncture, I think that first and foremost, if I could back up to your characterization of the prosecutor's position, I don't think that my reading of that transcript is that the prosecutor was kind of in the same boat as the defense. Did not think it was that big an issue and said that he didn't believe it rise to the level of a mistrial. So you have before you as a judge two individuals who are willing to go forward, and a mistrial is nonetheless declared. And importantly, I think that it's important to remember that this court is only to give deference to the trial judge's determination that manifest necessity required a mistrial here, if it's clear from the record that the judge gave careful, thoughtful consideration to alternatives and gave the attorneys an opportunity to be heard.
Counsel, it's clear that the judge had a lot of wheels turning in her head, and to a great extent, she's thinking out loud. And there's about a 1.5-page speech on the record where she started by saying something, and I'm paraphrasing because I don't have the transcript right in front of me, but she started with saying something to the effect of, I think I'm going to have to declare a mistrial. And then a 1.5 pages later says, okay, can we talk about trial dates? And in that 1.5 pages of transcript, including after the speech was done, defense counsel could have said, Your Honor, for the record, I would rather go forward with this potentially tainted transcript than I would to have a mistrial. And there is no objection anywhere in that. Instead, they started talking about trial dates. So
Correct.
How is this issue preserved?
So, Your Honor, I think that when looking at the record, this is not a situation, much like in Commonwealth versus Donovan, that the defense counsel, stood silent without making his position known. Because it's important to remember the touchstone of that requirement that an objection be lodged is to give the judge, one, the knowledge of what the party's desires are. And I think Attorney Cirillo's desire was unequivocally clear. I want no action to be taken. And at the motion to dismiss hearing, he reiterated that. And it's important to remember at the motion to dismiss hearing, counsel's recitation of the facts was never at any point contested by the Commonwealth or the judge. So it's my belief that it was the understanding of everyone involved that this was a mistrial declared over the defendant's objection because, one, the Commonwealth never at any point argues that the defendant's failure to object equated to consent. And I would say that that's because it was clear that both the prosecutor and defense counsel wanted to go forward. And in the motion to dismiss hearing, when the judge ruled, she expressly, her exact words were, I believe that I was in a situation where if I had allowed the trial to go forward, which inherently implies that she understood that this was not something that the defendant desired. And it's also important to look at where we're at in the trial. I mean, defense counsel is, everyone's aware that this officer had only made a few arrests, and the judge's concern was he probably hadn't done any trial. So this is an unintentional, lay opinion testimony that he gave. But you have experienced defense counsel having not even had the opportunity to cross-examine this officer yet. So really, perhaps if the defense attorney had cross-examined and it didn't go well, then maybe I could see the court construing consent. But again, I think we have to go back to the underlying principle of why that requirement's there. It's to avoid defense attorneys using double jeopardy as a sword, as opposed to a shield. When a mistrial is being declared, what we want to avoid is defense counsel standing by silently waiting until a jury is discharged and then saying, oh, judge, for the record, I object. Because even in those cases, the courts have held that that's an untimely objection. And at bottom, what we're always looking at is, was the judge given the opportunity to fully assess this? And going back to the deference given by this court, I would say that after the parties express their positions, the judge does not address the substance of either attorney's position. The judge doesn't say, well, you know, this is why, Attorney Cirillo, I think a curative instruction is absolutely necessary and why I'm not willing to go forward without it, or tell the Commonwealth's attorney that, you know, I think an instruction is warranted as well, or say why she doesn't think instruction will work.
So, counsel, if the presence of an appellate issue is not enough to declare a mistrial and have it retried, what is the relationship between the strength of the potential appellate issue and a finding of necessity? Because again, speaking for the moment only for myself, there is a Canty problem here. On the other hand, as you well point out, there are a few cases, including Canty itself, that reverse on the Canty grounds.
And that's and I thank you for bringing that up, because I respectfully have to disagree with this being a you know, Canty issue on all fronts, because really to me the crucial language in Canty is the ability to operate. That's the crux. The ultimate issue is not whether the defendant is under the influence, because as we know, it's not unlawful to be, you know, have alcohol in your system and drive. It's only unlawful if your ability to operate is impaired or you're over the legal limit. So to say I arrested him for operating under the influence of alcohol, I mean, I don't think that's prejudicial. One, because the jury has read the charge. We're here in this courtroom and you're all sitting in this box because obviously the officer believed this person violated that law.
Counsel, as I said before, you have your ADA hat on, and I have to say, it's whiplash to be having the two of you argue the opposite side of the merits of the Canty issue.
Can I just ask a technical question? Yes. You made reference to the representations by counsel at the motion to dismiss hearing. Do we have the transcript of that?
Yes, that is in the record appendix.
It's in the record appendix, okay.
Yes, and at that hearing, at multiple junctures, the defense attorney said that, you know, Your Honor didn't consider alternatives. You know, I asked for no action to be taken and to continue the trial. That's something that's reiterated by the prosecutor, that he verbatim says, counsel didn't want anything to be done, wanted to just continue cross-examining. And that's at record appendix 46, lines 11 through 12.
And isn't that statement ambiguous in the sense of, if the trial went forward, counsel did not want these things taken, as opposed to they were opposed to a mistrial and had objected. I mean, those are two very different things.
Correct, but I think that the court will find a lot of what happened in the trial can be gleaned not just from the trial transcript, but from the motion to dismiss hearing. Because what's important to remember is, you know, this is distinguishable from all of the cases cited by the Commonwealth in its, you know, consent portion of the argument, either procedurally or factually. It's always a situation in those cases where consent was either found by the lower court, and so that analysis has gone through by this court, or it was argued below which it wasn't argued below here, and the judge implicitly denied or rejected that argument by the Commonwealth. And so since it was raised again on appeal, the court addresses it. But this isn't either of those situations. This is in fact a situation in which it's clear that everyone in that hearing room on the motion to dismiss understood this to be an objection over the Commonwealth, because it's not ever.
I mean, why shouldn't we take what was said during the trial, again, for whatever it means, as opposed to add a gloss to it from the position the parties played out at the motion to dismiss stage?
So one, I would say that it's important to draw whatever inferences and extrapolations we can from the motion to dismiss hearing, because it was the same judge. If it wasn't, I would say it's almost difficult to get anything from that. But it being the same judge, that motion judge who presided over the trial, as we know, and as the decisional law in this Commonwealth has held since time immemorial, the trial judge is in a better position than anybody to know what was going on in that trial with respect to the position of the parties, with respect to the degree of taint that a jury, might have been subjected to. All of those things that may not be apparent on a cold reading of this record. The trial judge was in the position to be able to gauge that. And the fact that it's never argued at the motion to dismiss and never even brought up by the trial judge in her reasoning. Again, the only reasoning given by the trial judge in needing to declare a mistrial was the potential of an ineffective assistance of counsel claim, where I would say that was non-existent after the recess, where the defense counsel clearly articulated this was strategic. I would be hard pressed to find a case where a one-off reference concerning testimony that touches on the ultimate issue was enough to.
Counsel, we're gonna have to wrap this up. Let me see if my colleagues have any further questions. Seeing none, thank you very much. We will now hear from the Commonwealth.
Thank you. Good afternoon, and may it please the court. Assistant District Attorney Lindsay Russell for the Commonwealth. And I would like to just start here actually with the implied consent argument first. I do think the case is dispositive on that point, and therefore double jeopardy would not bar retrial in these circumstances. I understand that while the defendant suggests that his silence following the declaration of the mistrial should not be construed as consent, the case law does indicate otherwise. And the main case that I think is on point, and I would dispute what my brother just said about the cases not being procedurally in the same.
Counsel, you're starting to freeze up a little bit.
At least with respect to this Pellegrin case, am I okay now?
You're okay for the moment.
Okay.
You're talking so fast that Zoom can't keep up with you.
Okay, I'll try to slow down then. So I'd just like to point to this Pellegrin case where the SJC found that consent to a mistrial may be inferred from silence where the defendant had the opportunity to object and failed to do so. And in that case, that wasn't a case where it was found below that there was consent. This was found for the first time by the SJC based on the fact that the defendant, quote, plainly had the opportunity to object, in that the mistrial was declared after voir dire of the witness and colloquy and after the jury was cleared from the room, that therefore that silence there can be construed as consent. I'd also point to this DiPietro case that is mentioned in the brief, which is a First Circuit case where similar thing happened with improper testimony and the court sua sponte declared a mistrial. The court there found that there had been ample opportunity for the defense counsel to object because, much as the case here, for several minutes after the decision was made, both defense counsel and the prosecutor remained in the courtroom with the trial judge, listening to her explanation, yet did not object and even discussed acceptable new dates for trial.
But counsel, could you address your brother's arguments about how the motion to dismiss hearing went and the failure of either you or your colleague to raise the consent issue?
Right. So I will say it wasn't, I was not there at the motion to dismiss hearing. The way that I would say that what happened at the motion to dismiss hearing at that point is not as certainly not as relevant as what occurred at the time of the declaration of the mistrial. By the time of the motion to dismiss, there were arguments at that point being made along the lines of this manifest necessity analysis. And I can get into that as well, as that's our secondary argument. But I think, yes, defense counsel does say in that, at that hearing, basically like that he had been objecting to the mistrial. But I think it's clear that, and it's just on the cold record here, you have the record from the declaration of the mistrial that you can look at where he's clearly not objecting. And Justice Milkey, I think you brought up very poignantly the three alternatives that were here, and that was to give a curative instruction, which Canty says will alleviate the prejudice, which the defendant explicitly said he didn't want, or to continue on with trial without the instruction so that this uncured error sits there, whether, if a conviction comes back, or a mistrial. And what is clear from from the declaration of the mistrial, it's clear that the defendant wanted either to continue on with the trial with no curative instruction, and thus again having that uncured error basically inherent in any conviction, or in the alternative, he wanted a mistrial. Because what he definitely did not want, and was explicit about this both at the declaration of mistrial and at the motion to dismiss, actually, he was explicit that he did not want to continue on with the trial if the judge was going to be giving the curative instruction, which, as we know, Canty says is basically the one thing that can alleviate this prejudice. So at that point, the trial judge is in between a rock and a hard place there, because she's trying to follow the precedential case law in Canty.
Okay,
This is a clear error, and if you want,
if I can just stop you for a sec, there, as you've heard me say now at least twice, I do think there is a Canty issue here.
Right.
However, I have never seen any criminal case where there is not some appellate issue raised by how the trial progressed. That's the nature of this work that you know as well as I do. I would also add that in terms of reversible error, for the reasons that your brother has so articulately argued in this case, and you and your colleagues so articulately argue in real Canty cases, it seldom, if ever, results in reversible error. And we certainly can't have judges be declaring mistrials every time they're scared there's a legal error buried in how the trial went. So let me return to the question I asked your brother toward the end of his argument. To what extent is the strength of the potential appellate issue relevant to the manifest necessity issue?
if I could just back up to one of the assumptions there. Generally, when there are these Canty errors, there either is an objection, and even if there's not, maybe there is a sua sponte, the judge brings it to the parties, but a curative instruction given. So I would, a lot of the time we have that to rely on, where we say, well, there was a curative instruction and therefore this is clearly not prejudicial. I don't know of many cases where a Canty error goes undealt with, and then what the conclusion of that is. But generally, what happens is the curative instruction is given, or at least, and of course, that final instruction is always given, that the fact finder is, that the jury is the fact finder, and they shouldn't put more or less weight on any one witness's testimony, whether they be a police officer or not. But in this case, the defense counsel was explicit in that he didn't want any sort of instruction having to do with this. And it's been brought to everybody's attention. He just wants to move forward basically with what Canty has called a prejudicial error, and talks about how to alleviate it. Yet he does not want to alleviate that prejudice. And the judge doesn't want to give an instruction to the defendant's objection, because that could add a second error. And in that case, yes. So getting to the second part of your question, when it comes to evaluating the appellate issues, I do think that to the extent that the judge here engaged in basically an appellate analysis that a panel such as yourselves would get into, I think it was a little superfluous because, first of all, I do think this case is dispositive on the first issue of the silence resulting in acquiescence. But secondly, because, first of all, this court can affirm on any basis that's clear from the record. And I think it's clear here that when given those alternatives, she really had no other choice, where she has a way to cure the prejudice. And I would argue in all these other cases where we argue that there was no prejudice, it's because those curative instructions are given, because often the defendant does want that. I can understand it.
Counsel, to be fair, defense counsel was not crazy to say, I'd rather not have that curative instruction because it's only going to highlight the problem.
Agreed. I do think that was a strategic, I don't disagree that that wasn't a strategic decision on his part, but at the, so that even shows, that highlights more the position that the judge was in here, where she's trying to follow the dictates that says this will cure this error. And she's also trying to follow the reasonable request of the defense counsel saying that I don't want that because it's going to bring more attention. So the only other alternative, just in fundamental fairness, she doesn't want to go forward with a trial without curing the error. That would be unfair to both sides, really. And I also think it's interesting that in this articulation of manifest necessity, we ask whether there's been manifest necessity or the ends of public justice would otherwise be defeated. And I think that that's important here to color really the analysis of the manifest necessity and the fact that there really was no other option here. And if we are looking at those two prongs, she's clearly, under manifest necessity, she's clearly giving both sides a full opportunity to be heard. I really don't think there's any dispute about that. And then secondly,
let me just stop you right there. Would you at least acknowledge that perhaps it would have been better had the judge turned to defense counsel and said, okay, in a choice between a mistrial and moving forward under these two options, which would you prefer?
I think in a perfect world, it's always good to be explicit in communications. But in this case, I think that was implied, that it's clearly we're either going to continue on with this trial without a curative, which I think is out of the question in terms of what the judge, or we can go forward with the curative, which I think probably would have been the best way to go, but defendants clearly didn't want that, or there's a mistrial. I think it was implied that those things were on the table. But yes, in a perfect world, that clarity would have been helpful and maybe we wouldn't be here today, but that isn't what happened. But I don't think that means that, again, there wasn't manifest necessity. And then also getting back to, I don't think that means that the defendant didn't then acquiesce because he didn't want to go forward with the curative. He didn't want to cure the prejudice. So therefore, to him, a mistrial was the next best thing, which I would suggest is why he did not object at that point. And I would just, if there are no further questions, I would rest on my brief.
Seeing none from my colleagues, I want to thank you both. Excellent arguments on both sides, and the case is submitted.